Do we want to go ahead and invite our group into the meeting, and then we can do roll call?
That's great. We have started the webinar, and folks should be populating our meeting here.
All right. Good morning, Colorado. This is the meeting of the Colorado Oil and Gas Conservation Commission. We are on day something or other in rulemaking on mission change. I don't know exactly. We have taken a short break from our rulemaking. We've received all of our public comment and our stakeholder participation in the 2 through 600 series. This morning we are set for closing statements followed by deliberation. And to kick it off, we would ask Hearings Officer Larson to please take the roll.
Certainly, Mr. Chair. Commissioner Gibbs.
Here.
Commissioner Gonzalez.
Here.
Commissioner McGowan. Oh, Commissioner McGowan, you're still on mute.
Here.
Thank you. Commissioner Mesden.
Here.
Commissioner Nanjapa.
Here.
Commissioner Putnam.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 7 out of 7 commissioners present.
Excellent. All right. So we are all here. We're all ready. We're all rested, and we look forward to initiating the mission change rulemaking with closing statements this morning. I believe that we have exactly 94 minutes of closing statements from our parties. We have the time allocations. Ms. Larson, thank you for the cheat sheet. It helps me as we go through with this. We will be moving into closing statements this morning, and then we will be breaking after closing statements, and then we will move to commissioner deliberations starting at 2 p.m. today. So that's the order of business. With that, I see that Ms. Larson is bringing on Industry Group 1 panel. Once we have this panel on board, we will get started with it. And in my daughter's honor, just ring the gavel to show that we are legit. Mr. Matthews, are you leading the charge here, or Mr. Martin, or Mr. Neslin?
I am, Chair Robbins. I will be speaking first. The others will follow me. We'll try and be as efficient as possible since we only have 6 minutes. Should I proceed, Chair Robbins?
Yeah, one last sort of procedural element to this. Each party has their allocated time. I know that certain parties have coalesced time or donated time to other parties, which we've allowed. We also know that there are sometimes multiple entities that will be speaking, or multiple people, and that's fine. Ms. Larson will be keeping track of time. And then following the closing statement, commissioners will have an opportunity if there are any questions for the participants from that group. So with that, Mr. Matthews, you're up.
Thank you very much, Chair Robbins, and I very much appreciate the opportunity to speak to you this morning. I will be speaking on behalf of COGA with regard to the extended setback in the 600 series. COGA believes that there is not substantial evidence in the record to support this extended setback, and that is the requisite standard under the State Administrative Procedures Act. COGA also believes that this extended setback is neither reasonable nor necessary as required by SB 19-181. And this is because, in part, the Commission has chosen to ignore or at least not give sufficient weight to the best evidence in the record regarding the need for an extended setback, and that is the testimony of Dr. Tammy McMullen, who testified regarding her evaluation of over 6,500 data sampling points and concluded that there was no scientific evidence for an extended setback. I want to point out that the only other professional witness or party witness who is a licensed toxicologist, Dr. Deborah Caden, reached the same conclusion. It's also in part because I think the Commission gave undue weight to the 2019 health risk study. As has been pointed out, even by Dr. Richardson, the report is explicit that it was only considering worst case scenarios, and indeed the word highly conservative and conservative appears through virtually every aspect of the modeling. Significantly, the report also admits to a very high degree of uncertainty, or I'll just say a high degree of uncertainty. It states, quote, "There is a high level of uncertainty in the representativeness of the sampled emission rates to real emission rates in the oil and gas areas." This is because, first of all, there's a very limited number of samples used by CSU. Second of all, these were only 3-minute samples and had to be extrapolated to an hour. And third, these were non-continuous sampling data. So not surprisingly, the report concludes that more detailed air sampling, and in particular, more continuous air sampling data would, quote, "allow for a better understanding of the real world patterns of exposure near oil and gas sites, as opposed to the probabilistic methods used in the health risk study." And that is precisely what Dr. Tammy McMullen did after this study. Thank you.
Commissioners, I'm Dave Neslin. I'm speaking on behalf of Noble, Occidental, and PDC. We agree that the record doesn't support a 2,000-foot hard setback, but we read Rule 604B to create a softer setback that ensures development within 2,000 feet is properly protective. And to this end, it's imperative that the rule provide meaningful, attainable, and timely pathways for approving such development. We'll need to seek such approval for numerous locations which can and should be developed while protecting the public and the environment. And such locations should be approved through a single Rule 510 hearing on the oil and gas development plan, and not through a separate variance process that involves different standards, another hearing, and greater complexity and uncertainty. And like virtually every other party, we urge that the substantially equivalent protection language be omitted or clarified. This language needlessly modifies the statutory standard, which appears more than 100 times in the draft rules. And it's confusing. Some parties read it to mean that the location must have the same effects as a location 2,000 feet away. But that improperly elevates the blunt tool of distance over more precise tools like facility design, technological controls, and BMPs, which may be more effective. And it may transform Rule 604B into a hard setback, a point that several parties acknowledge or expressly advocate. And that's because noise, light, and other impacts will typically be greater at 1,500 or 1,000 feet than at 2,000 feet, notwithstanding any BMPs, and even though the impacts still meet regulatory requirements at 1,000 or 1,500 feet. I want to emphasize that Senate Bill 181 and all other draft rules use one standard: protecting public health, safety, welfare, the environment, and wildlife resources. And that standard should be used here without modification. A 2,000-foot distance is one means to that end, but it's not an end in itself. Finally, many of the problems we identified in Rule 218 persist. These problems are summarized in Noble's written closing. We would welcome the opportunity to resolve them with the staff. Thank you.
Good morning, Commissioners. I'm Jim Martin, speaking today on behalf of API Colorado. I want to hit just a couple of points very briefly. First, API Colorado fully supports Mr. Matthews and Mr. Neslin's closing statements with respect to Rule 604B. We agree the record doesn't support it, a hard 2,000-foot setback, but if there is to be such a setback, a soft setback, we urge the Commission to ensure that the 2,000-foot setback provides reliable, meaningful, predictable off-ramps in appropriate cases. Second, most of you likely were not listening in on the Air Quality Control Commission's deliberations last night, but they added an entirely new layer of regulation on oil and gas completions that will dramatically reduce emissions of both VOCs and HAPs and further minimize any potential exposure during those completion operations. Those new regulations require control of emissions from flowback vessels by 95%, as well as periodic flowback vessel and control device inspections. These measures highlight the steps being taken both voluntarily and through regulatory requirements to reduce potential human exposure from oil and gas operations, including during flowback operations. They also provide even more support for a viable and meaningful exception pathway under 604B. Third, API Colorado also reiterates the arguments we made in our brief on standing. We believe that providing automatic standing to anyone who lives within 2,000 feet of a location cannot be reconciled with the Colorado APA. Last, while we appreciate the staff's revised standard at 303B for denial of an oil and gas development plan, we note that the standard for approval continues to provide no fair warning to operators of when applications will be approved. We also note that the standards at 307B for approval or denial of an application differ from the standards at 303B. We continue to believe they fail to provide fair warning to operators of when and under what conditions an application will be approved or denied. Thank you, Chair Robbins and Commissioners.
Thank you, industry group. This time we would turn to questions from commissioners, and I see that Commissioner Putnam has raised his hand.
Terrific. Thank you, Mr. Chair. And Mr. Martin, glad to see I wasn't the only one tuned into AQCC last night. And it is an important rule, so I appreciate your noting that. I think the questions I had, and I had a series of them, were for Mr. Neslin related to the PDC closing statement. And the statement was made in there that COGCC can't use this information, and by information it meant mobile source emissions, in its decision-making processes to regulate oil and gas operations. So my question is, at least the first question, is it your position that the state cannot regulate an oil and gas site as an indirect source under Clean Air Act Section 110A5, which is the subject of the National Association of Home Builders case you cited?
Mr. Neslin, you're muted.
Commissioner Putnam, I would want to give that a little bit more thought to respond to your question about the specific case. I think in our view, as a general proposition, EPA has been given jurisdiction over mobile sources. And the collection of information by the COGCC, apparently under the rules, would lead to some form of regulation. The information would be used for some regulatory purpose. And so as set forth in the PDC written closing, we're concerned that that would intrude upon the EPA's jurisdiction and exceed the jurisdiction of the COGCC.
So is your argument then that the Ninth Circuit reached the wrong conclusion in the National Association of Home Builders case when it found that a state agency or a subdivision could regulate indirectly under Section 110A5 of the Clean Air Act?
I want to, as I said, Commissioner Putnam, take a further look at that case and the specific facts of that case and consider how they might apply to the Commission's regulation of mobile sources in this proceeding or as a result of the 900 series proceeding. And I'm at a little bit of a disadvantage given that all we have at this point is a request for the submittal of the information, and it's not clear how the COGCC intends to use that information. Again, either in connection with its permitting decision and the imposition of conditions pursuant to its authority under the 300 series, or in connection with the 900 series rules, which have still to be discussed and deliberated.
So I'm a little troubled because you drew an absolute conclusion that COGCC could not use that information based on a case you cited, and I'll argue probably miscited because you didn't actually cite the holding of that case, but now we're not prepared to explain why it helps support the conclusion that you reached.
Commissioner Putnam,
Let me just clarify then with another question. If, as an example, an application were to use an older fleet of frac engines that had 10 times the particulate matter emissions and 3 times the NOx emissions of a new Tier 4 fleet of frac engines. Is it your position that the commission can either consider that for cumulative impacts purposes nor act in any way based on that information?
Mr. Neslin?
Yeah, Commissioner. I think it would depend on how the commission chooses to act based upon the information.
And if that's the case, was
A concern. Yeah.
so if that's the case, was the statement in your closing statement that the COGCC cannot use this information in its decision-making process an overreach?
For regulatory purposes, maybe it's a question of how decision-making process is construed. I think cannot use the information for regulatory purposes might be a better characterization. But I don't think that the statement in the written closing is inaccurate, Commissioner.
Okay. I do suggest that you and others take a look at that case because I think it leads to the opposite conclusion. But I'll move on to the next set of questions that I had, and they related to the comments in there about the provisions of Draft Rule 303A 5B.
Commissioner Putnam, you've gone silent on us.
Can you hear me now?
I can. If you could start over with your question.
Sure. So the next question I have is on a slightly different subject related to, I believe it's page 3 of the closing statement, relating comments on Draft Rule 303A 5B Romanet 2C.
Commissioner Putnam, unfortunately, you
Am I cutting out again?
Yeah, you cut out again. Maybe stop your audio, maybe? I don't know. And then we can see.
Let me just quickly try to get the question out. It relates to a qualitative assessment of public health effects associated with certain hazardous air pollutants. And the concern was that it would require quantitative air modeling and air dispersion modeling. And I'm wondering how you reach that conclusion that a rule that says qualitative requires a quantitative analysis.
That answering the information about the health impacts would require some modeling, modeling to determine the dispersal of the emissions, their presence and the duration of their presence in the air and the exposure to individuals. I think we tried to spell that out in the response. I apologize if that wasn't entirely clear. Again, we were dealing with a limited number of pages.
And maybe you can just help me on that. If the previous section required a quantitative assessment of emissions, and that does certainly require some degree of modeling, but the discussion about qualitative effects uses distinctly different word of qualitative, how that leads to the conclusion that you have to have a quantitative analysis to do that.
To determine the basis for the potential health impacts. That was the reasoning. I acknowledge that the provision in question uses the word qualitative, but even for purposes of developing a qualitative projection or estimate, it was our concern that that would require some modeling for the reasons I tried to explain a minute ago.
Okay.
Perhaps if that's not the intent, Commissioner Putnam, perhaps that could be clarified in the statement of basis and purpose.
That sounds good. Thank you, Mr. Neslin.
Thank you, Commissioner.
Other questions from commissioners to this panel? Commissioner McGowan.
Thank you, Mr. Chair. So regarding I will not do the 208CD 1A dueling lawyer language. The transfer of assets issue that we still seem to have, I was hoping that you all would be able to work with staff. And I think that Director Murphy is with us. And I'm just wondering if there's still a way for us to keep working on that language so that staff gets what they need, which is what belongs to whom at what point in time, and so who is liable if something happens, and also meeting your needs, which is sometimes we don't know until we're actually signing papers, for example. So I'm wondering if we still have some place to have some resolution, or are we, is staff kind of stuck? I'm just curious.
Commissioner, one of the challenges, given the wide range of rules we're dealing with, has been, finding time to get with staff who are very busy, understandably as well. And we've been busy working through this rulemaking process. This is one of our highest priorities. I would be happy to, and my clients would be happy to work with staff, meet with staff, speak with staff this afternoon. I believe this is a solvable problem. I believe that we can achieve the staff's objectives in connection with Rule 218 and address the concerns we've articulated in Noble's written closing, and that I believe High Point articulated in their written closing. I think this is solvable in a way that works for both sides, and we're committed to spending the time, if it's this afternoon or Monday or Tuesday, whatever works for the staff, even over the weekend, to make that happen.
Great. I don't know if Director Murphy wants to say something if I've just offered up staff for something they don't want to do. So
Yeah, I think what I would suggest we do is staff is listening to the Q&As, and once we're done with closing and as part of deliberation, we certainly have the opportunity to ask questions of staff. And so I would like to ask staff that same question. So if Director Murphy could make a note, that way we can expeditiously get through closing, and then we'll have a one-on-one opportunity with staff. Is that all right, Commissioner McGowan?
yes, thank you, Mr. Chair. I'm wondering if we could also add a discussion of the rules regarding APA and who has standing and what that means exactly. I had a discussion with AAG Davenport last night, and I think there's maybe a distinction that's being missed as part of the intent of the language that are in the rules. And so if we could have a discussion about that, I think that would hopefully clarify some things as well. And then the substantially equivalent language, I'm wondering if you could just talk a little bit more. Are you arguing that we should get rid of the substantially equivalent language, or that we should better define it?
Commissioner, I would urge you to get rid of the language, and I say that respectfully. I accept that it was introduced into this with the best of intentions, but I think the fact that virtually everyone who submitted a written closing either argued that this language be omitted or interpreted it in a dramatically different fashion suggests that it's neither helping to achieve consensus or clarity. There is statutory language about protect public health, safety, welfare, the environment, wildlife. We're prepared to live with that language. That language appears 9 times in the Act. In Senate Bill 181, it appears over 100 times in the draft rules, and it appears over 80 times in the Statement of Basis and Purpose. We don't believe the substantially equivalent modification is necessary. We're particularly concerned about interjecting additional uncertainty in a rule as important as this rule, dealing with a setback requirement, and so it's a source of real concern for us. And as I tried to briefly explain, I personally am afraid it's going to give rise to a harder setback than you intend. As a practical matter, things like noise, and light are attenuated somewhat with distance. And so even with the best of design and technological controls and BMPs, the noise impact may be greater at 2,000 feet than it is at 1,200 feet, let's say. Even though the noise at 1,200 feet meets Rule 423 and meets the criteria that you've adopted for this purpose, does that mean the location can't be located at 1,200 feet because it's not substantially equivalent to what it would be at 2,000 feet? That's the sort of uncertainty I'm concerned about.
Thank you.
Thank you, Commissioner McGowan. Thank you, Mr. Neslin. Commissioner Messner, I think, has a question.
Thank you, Mr. Chair, and I appreciate the testimony. A couple of questions. So I'm assuming that operators within this group have had applications, permits approved under the director's criteria over the last year and a half.
Yes,
Yeah.
Commissioner.
Okay.
Testify to that.
Within that director's criteria, it clearly indicates that within 2,000 feet, understanding it started at 1,500 feet and then transitioned to 2,000 feet, but that within 2,000 feet, there was additional scrutiny necessary in order to ensure protection of public health, welfare, the environment, and wildlife resources. Is that correct?
That is my understanding, Commissioner, as to how that's working. And let me add that we would hope that Rule 604B in practice would work like the reviews that have been conducted under the director's objective criteria.
And so within the director's criteria and within that 2,000 feet setback that initiated the need for the criteria, there were additional techniques, technologies, best management practices that were needed to be employed by operators in order to be able to get permits approved within that 2,000 feet. Is that correct?
Commissioner, I don't know that that is true. I would agree with you that the staff scrutinized those locations to ensure that public health, safety, welfare, the environment, and wildlife were protected. I don't know whether in any particular instance that required some additional technology or condition.
Or best management practices. Well, I know with individual conversations with operators that is true in many circumstances. I do wonder, understanding that we've got 2,000 feet and that best management practices or different mitigation measures in order to avoid, minimize, mitigate adverse impacts within that 2,000 feet, we're part of a lot of applications and approvals through the director's criteria, and maybe did not have to happen outside of 2,000 feet. I guess I'm wondering, what the concern is about employing additional best management practices, technologies, and techniques, mitigation measures within that 2,000 feet, which gets to substantially equivalent.
I'm sorry, Commissioner.
Mr. Messner, you're popping out on us. Sorry.
Well, I apologize. Is that okay? Am I okay here?
Yeah, it's better if you hold it up.
Yeah. So going back to the initial question, understanding that there were additional best management practices, mitigation techniques, within the director's criteria that resulted in approvals, within that 2,000 feet, and that operators were able to achieve those. I guess my question is that not the definition of what substantially equivalent would be in order to be able to employ those things within that 2,000 feet?
Commissioner, I'm not sure what substantially equivalent does mean. And I think if you read the written closing statements, you'll see different parties construing it in different ways. And I would suggest, look, it's very hard to write statutes, and it's very hard to write regulations that are good regulations, that are clear and concise. I would suggest that, you know, adding additional modifications to the statutory standard in a way that is construed differently by different parties may lead to ad hoc decision-making, may lead to confusion and additional uncertainty about what is required and what the basis of a decision was. The statutory standard is protect public health, safety, welfare, the environment, and wildlife resources. That is the standard. I don't believe that requires additional modification. If BMPs or design modifications or technological controls are required to meet that standard for the location in question, then of course I agree with you. Those measures should be employed, and that's appropriate. If they're not required to meet that standard, then they're not required. Again, the Senate Bill 181 doesn't refer to a 2,000-foot distance or any particular distance for this purpose. It refers repeatedly to the formulation I've just quoted.
Thank you. And I appreciate. So, I mean, I do think there needs to be deliberation to ensure that there's clarity around any language that's utilized, whether that's substantially equivalent or something different. I do think it's important to understand whether that language is just utilizing protect and minimize, or whether that language, you know, is substantially equivalent, that it's clear that, you know, as you get inside of, you know, whatever the ultimate setback ends up being, and under the director's criteria, that was 2,000 feet, that additional steps may need to be taken in order to meet that standard. And so I'm open to having discussions around that and finding the correct language, but I'm not sure that just utilizing blanket language accomplishes that. But we can have further discussions about that through the deliberations.
If I could, Commissioner, if I could just briefly respond to that. I think I understand your concern. I do think the statutory standard of protect public health, safety, welfare, the environment, and wildlife is broad enough to address what you just said. If some additional BMP or control technology is required to meet that standard, it can be required. I would also note that the 400 series, in setting forth specific criteria for things like noise and light, set them forth at the receptor, right? No, whether you're 2,000 feet away or 1,000 feet away, you've got to meet the noise standard at the receptor. The light is measured at the receptor. So I think that helps to address your concern as well, sir.
All right, thank you for answering those questions.
Other questions from commissioners to this panel? All right, I'm not seeing further questions. Thank you, panel, for your closing. Ms. Larson, we would move to Industry Group 2.
There we go. Can you hear me?
We can. Good morning.
Good morning. Thank you. My name is Kelsey Wazelinki. I'm with Jost Energy Law. I, along with Jamie Jost, represent Crestone Peak, Great Western, High Point, Mallard, and Nickel Road in this rulemaking. Our clients assert that the 2,000-foot setback should be reduced to a distance that is determined by all of the available science and based on current technology, current operator development practices, and current production methods. This commission is mandated to protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources with reasonable and necessary measures. 2,000 feet is neither. As outlined in closing statements, staff has reviewed and analyzed vast amounts of air quality data submitted by operators and third parties both before and during this rulemaking process. The findings from the CTEH dataset, in addition to recent site-specific air monitoring data from operators, indicate the compounds that may be emitted during pre-production operations, including benzene, are not expected to cause adverse health effects to nearby residents and are materially below already conservative health standards. Because there is no reasonable or necessary basis to adopt a 2,000-foot setback in Rule 604, this setback distance should be significantly reduced and determined by a commission-developed study based on current technology, current operator development practices, and current production methods in the various operating environments of Colorado. Furthermore, our clients outlined several issues with and requested changes to the 4 proposed off-ramps. We are all concerned with the new ambiguous standard of substantially equivalent protections in Rule 604B4. This standard does not comply with the APA and should be replaced with originally proposed Senate bill standard to protect and minimize adverse impacts. Equally concerning is the proposed automatic standing for surface owners and residents of building units within 2,000 feet of a working pad surface in Rule 507A2. This allowance for automatic standing violates the APA and also effectively confirms that each person is adversely affected and aggrieved by oil and gas development, despite the vast amount of scientific and technical evidence to the contrary. For these reasons, we request that Rule 507A2 be deleted. For Rule 218's transfer of permits and subsequent liability provisions, these do not reflect responsible party provisions of the Act and should be revised. And we are also ready to work with staff on this rule per your discussion with the prior panel. Finally, our clients appreciate the continued collaborative work on Rule 411. While we agree with staff's approach in Rule 411, we urge the Commission to adopt clear language in the Statement of Basis and Purpose to, number 1, defer to the unique expertise of a public water supplier and operator for a strong presumption that a variance will be granted when a waiver of an internal buffer zone is presented, and number 2, defer to an operator's protective best management practices when considering whether to expand any buffer zones to include ephemeral streams. Thank you for your time and attention to our clients' positions as you proceed with your deliberations.
Thank you for that closing statement. Are there questions from the commission? Commissioner Gonzalez.
Thank you, Mr. Chair. Good morning, Ms. Wozlenke. I've got a question about 604B and some of the conversation that we've had with you and with the previous industry group that was just on. And I'm curious, about the talk about it being a 2,000-foot setback, because as I read the rules, there's siting requirements for wells to be sited within 500 to 2,000 feet. Under 604C, it's not necessarily a setback. Am I reading that incorrectly?
I think our clients would respectfully disagree with that position. I think while we may understand the intent of a soft setback, I think we're pretty concerned with how the off-ramps would work in practice. We've got a lot of clients who even operate in more rural areas who would lose, as we stated in our closing statements, a significant amount of surface acreage. There's a lot to take into account when you're looking at a 2,000-foot setback and those off-ramps. So I think we are still very concerned with this. I don't think we see it as a soft setback that can be waived, as it currently, as we're operating under the objective criteria. I think we're concerned with how those off-ramps will play, and also with the number itself. I think there's a lot of evidence. I think we're presuming here that 2,000 feet is the protective distance, and we would urge you to consider, as industry, the panel group 1 just presented to you, the site-specific data that has been generated that doesn't show that 2,000 feet is the number.
But without wading into the exact number, and I think that's going to be left up to us for deliberations, hearing from your testimony, the rest of the testimony we'll hear today, and all we've heard in the weeks past, it just seems to me as if there isn't an exception that's being sought for a setback here. It seems like there's additional requirements that are being added to permitting in that certain buffer. And I'm just trying to reconcile that with industry's position on 2,000 feet being a setback, because I just don't know if those two are aligned just yet. And perhaps, you could help differentiate that for us.
Sure. I think and I appreciate the discussion. I think our largest concern, frankly, is the number of 2,000 feet being presumed to be the protective distance. And you've got to go above and beyond to show that you can operate within that setback. We do see it as a determined distance based on health, and there's evidence to the contrary. So, I think staff proposed an approach at the outset of this rulemaking that was not adopted during your discussions, and we would just simply ask that you reconsider what is the protective distance and look at the evidence and look at what operators are doing. Technology is changing every day, and and we think that a lot can be said about this site-specific data that's been presented to you, to move away from 2,000 feet being the presumptive distance to be protective. We think it's much less than that.
Thank you.
Ms. Wazelinski, you mentioned in your closing that the commission should do its own developed study based on current operations in Colorado. That obviously was something that the commission attempted to move into following release of the CDPHE study, and we've made some steps in that direction, but with COVID-19 and other unexpected events, that has not gained as much traction as we would have wanted. On behalf of your clients, would they be willing to participate in a go-forward study along those lines, if you would care to comment?
Absolutely, yes. I can say wholeheartedly that our clients would be more than willing to participate, and several have already helped in that aspect and are leading the charge on air monitoring at their location. So yes, I think that's the direction where this should go. I think you should use our clients' expertise in this matter and all of the technology that's being implemented, and work together to find something that's workable and complies with the Senate bill of necessary and reasonable.
Thank you. Other questions for this panel? Great. Thank you for your closing statement. Thank you for your client's participation in this important rulemaking. We will now move to the next group, which is 350 Colorado, as well as some other folks in that group. See, we have Ms. Merlin has joined us. Good morning, Ms. Merlin.
Good
Mrs.
morning.
Merlin, do you have Ms. Parkin as well, or are you on your own?
I believe I'm on my own this morning. I texted her, she didn't respond.
Then the floor is yours.
Thank you. I prepared a PowerPoint presentation. I saw that industry didn't use any, and I was wondering if that was permitted.
Fine by me. Commissioners, are we all okay with PowerPoints if they want to do it? Yep, you got all kinds of thumbs up. So
Okay.
go ahead and load, share.
The host has disabled screen sharing, so I'll need that enabled.
Give us just a second and we'll get that enabled.
It's enabled, Ms. Merlin.
Okay, thank you. Okay, let's go back to the first one. Okay, good morning. Thank you, Commission. My name's Catherine Merlin. I'm here to present on behalf of 350 and the other groups. I wanted to start this morning by using a famous quote that I think is very appropriate to this rulemaking proceeding, which is from Upton Sinclair, that it's very difficult to convince a man of something when his salary depends on his not understanding it. And unfortunately, the industry's salary depends on not understanding a lot of the health and safety implications of the activities that they do. There's been a lot of inconsistency in the scientific data that's been presented to you. And I would argue that the most credible data that you've heard has been from the state and the independent scientists who testified. And additionally, I'd push back against industry to say that testimony from the lived experiences of human beings is also credible evidence that you are allowed to consider. Furthermore, some untrue things have been said during these proceedings. I'm referring to a statement that was made on September 10th regarding the safety of operations in riparian areas. It was mentioned that they've been operating safely in Western Slope corridors for a long time, but that's just not true. In 2013, we saw a very serious spill in Parachute Creek. I won't run through all of the suggestions that we've made, and a lot of them have been adopted through, have been put into the September 18th draft proposed rules, and we thank the commission staff for that work that's been done. As I told you at the beginning of this proceedings, this is the fourth time that the Commission has attempted to implement health and safety regulations. Since the last time two trends have collided, the trend of having megapads, very large industrial facilities, and residential fracking. Industry dislikes the language in 604B about substantially equivalent protection because, one, there's no substantially equivalent protection to distance. And two, other than that language, B4 would be by far the easiest exception to meet to that soft setback. So I would encourage you to keep that language or get rid of 604B. This is just a small list of the federal environmental statutes that the oil and gas is either completely or partially exempt from. You guys are really the defense that we're counting on. And then this is the last slide. I would just like to emphasize that all wells will leak over time. We are in a climate crisis. Industry is pounding on the front door of densely populated Front Range communities that vehemently do not want residential fracking. Thank you very much for the work that you've already done, and please use your deliberations to finish the work of protecting people and the environment.
Thank you for that presentation. Do we have questions? Okay, I'm not seeing any questions. Thank you for your closing. Thank you for your 4 pages of written closing comment, and thank you and your groups for your participation in this important proceeding. We really appreciate it.
And thank you all.
All right, I think we're moving to Adams County. See, Mr. Dean has joined us. We're looking for Ms. Fitch, perhaps.
We are. Mr. Dean, do you know if Ms. Finch is able to, oh, let me see. I see a raised hand. One moment.
You literally just got booted.
Hopefully that raised hand helped you all find me.
Yes, we see.
So Greg is going to do most of the presentation today. I am really just running the PowerPoint. So I'm going to share screen and then pass it over to him. Can everyone see my screen?
Not yet.
Ooh. Let's see. Oh, there it is. Now can you see my screen?
We can. Thank you.
Great. All right. Take it over, Greg.
Good morning. This is Greg Dean, Adams County Oil and Gas Liaison. The county appreciates the efforts of the commission and staff to incorporate the varying perspectives from stakeholders into an objective, insightful, and astute set of regulations that addresses the changed regulatory environment and that are protective to public health, safety, welfare, the environment, and wildlife. The county is largely supportive of the September 18th draft with only limited suggestions. First, we appreciate the substantial changes as proposed in 301F that will immensely improve the relationship between local governments and the COGCC while honoring the purpose and intent of 181 for a cooperative co-regulatory framework. We also support the inclusion and modifications to the CITER repository rules. However, we do request added details and guidance documentation be provided regarding the expected format, scale, source, and availability of these data. Ultimately, we believe CITER will be a useful tool in evaluating cumulative impacts and simply want to ensure that the data is collected in a manner that is consistent and comprehensive and yields meaningful outcomes that will undoubtedly impact future regulatory and permitting decision-making. We further support the inclusion of the surrounding oil and gas impact provision and believe this, in conjunction with the requirement for cumulative impacts plan for all proposed facilities, will adequately address potential cumulative impacts. As staff presented, we agree that the intention of an ALA should be to evaluate all advantages and disadvantages of proposed oil and gas locations and only select one that meets the commission's requirements and is least impactful. To that end, the county wholeheartedly believes that an ALA should be done for all proposed locations, even those that meet setback provisions. Requiring an ALA in all instances is not only significantly more protective, it ensures impacts to each resource is being evaluated equally, but also provides a high level of regulatory certainty for the public and others that permitting an oil and gas site is being done by this commission thoughtfully and intentionally as to mitigate and avoid those impacts. Next slide. The county appreciates the incorporation of a lower maximum C-scale noise into the September 18th draft. However, we believe allowing an exception to those newly reduced noise levels for pre-production operations is not protective and negates such much of the benefit of that improvement. Drilling and completion operations are the noisiest part of development and is the source of most of the noise complaints filed in the county, and we respectfully request this provision be removed. Next slide. Lastly, the Adams County Board of County Commissioners has reviewed and are supportive of the proposed 2,000-foot setback from residential building units and school facilities. We seek added clarification, however, into the allowable exceptions to those setbacks as defined in 604B1 through 4, as some of the language seems confusing. There's also a question as to whether such exceptions will be granted administratively by the director or through some public review process. Thank you again for allowing the county to be an active stakeholder, participant, and partner in this rulemaking process.
Thank you, Mr. Dean and Ms. Finch. Do we have questions? Commissioner Nanjapa? Nope, I'm sorry. Thought I saw a hand raised. Other commissioners with questions? Oh, Commissioner Nanjapa.
You did make me think of one now.
Let's do out.
Thank you very much, Mr. Chair, and thank you both for your testimony. If I recall correctly from your previous testimony, you all had established a 1,000-foot setback in the county. Can you, I appreciate that you're supportive of the discussion so far, what the staff has presented in the rules. How do you foresee this impacts your decision-making going forward?
So I can speak to some of the more technical side of it. So we have presented this to our board specifically, and they are supportive of amending our regulations to increase our setback. Again, we will always measure our setbacks from the edge of the working pad surface to the parcel line. That's just how the county is going to administer our setbacks in oil and gas regulations. So we'll have to do some internal review to see how 2,000 feet in the commission's rules would translate into a setback at the county level, because we still, we want to increase the setback, but we also want to be protective of parcel lines and people's yards and things like that. And I can let Ms. Fitch address more of that as well.
I do think Greg covered most of it. So the commission did have a chance to take a look at the 2,000-foot setback as proposed. And as Greg said, ours is currently measured from working pad surface to property line and does have the ability for public hearing waivers. So that's one of the things that we had kind of requested a little bit of clarity on this new Rule 604. And then kind of that entry paragraph on Rule 604 is a little confusing. So just kind of some clarity on that, but it is very similar to what the county is looking at going forward.
Great, thank you. And I think as drafted, obviously we need to go into deliberation, but as drafted, the 604 waivers, in particular, the fourth one is based upon a hearing. So Commissioner Putnam, did you have a question? I see you unmuted yourself.
Yes, thank you, Mr. Chair. And I had a question for Mr. Dean, just to follow up on your comments about cider. And I think certainly from CDPHE's perspective, we also share the hope that it could be a really useful tool. Curious just to follow up on your comment on providing more guidance on methodologies and approaches to doing, for example, emissions characterization. Is your recommendation to do that through regulatory language, through guidance, through a stakeholder process? Kind of what do you have in mind in terms of providing that, a balancing, the need for maybe to have that evolve over time, reflect best practices, and, be as efficient as possible?
Yeah, that's an excellent question. And when I initially read this rule, my first gut reaction was a guidance document with a stakeholder involvement. Obviously, there's a lot of local governments and other parties that are experts at a lot of these different avenues. And similar to the AQCC Reg 7 rulemaking that wanted to remain flexible, especially as technologies are advancing, we acknowledge that, and we want to keep that flexibility in this regulation. So like I said, my first gut reaction would be a stakeholder-led guidance document. And we're not concerned necessarily with the intent of the rule. We're just concerned that we just want to make sure that operators are clear that what the scale of the data is, because our one big issue is that you'll get data submitted to the commission that's in various scales and different formats, and we want to make sure that it's useful to the commission and CDPHE so that they can actually take that data and make meaningful decisions from it. So you don't have 10 different formats and different scales of pollutant levels or whatever you're requiring in each of the resource parts. So that's kind of the way that we envision, and we would obviously love to be involved in that.
Thank you, Mr. Dean.
Other questions for this panel? Great. Thank you, Adams County. We have appreciated your thoughtful and pointed considerations that you have brought to us, which I believe is very helpful to our process. Appreciate your closing statement and your closing 4-pager. We will now zoom you away and bring in Affiliated Local Government Coalition.
Good morning, Commissioners. Elizabeth Pranos here. I think Kate Burke from Boulder County is also joining us, and she's going to start the presentation today, and then I'll take off where she leaves. So as soon as Kate's available, we'll get going.
Looks like we are seeing Ms. Burke's screen.
All right, sorry about that. Can you all see the slides?
We can see your slides. You don't have it in slideshow mode. I don't
Okay,
think.
my screen is confusing me.
I'll give you a second to. Some folks like it not in slideshow mode, I've heard, but.
No, I want it to be. It is on my screen, but All right, hold on. Let me kind of start over here. How about that?
We're still seeing your first slide and also a smaller version of your second slide.
Right. Why are you seeing that? All right, well, we're just gonna have to go this way. There's no notes. I can't figure it out at the moment. But you can see those okay? Even though it's not?
Yeah.
Okay, we'll just handle it that way. Sorry about that. All right, good morning. Kate Burke again from Boulder County Attorney's Office on behalf of the ALGC. We very much appreciate the commissioners and staff's monumental work on the rules thus far, and we do see some great forward strides. And of course, we have some requests for changes. So going in order of the rules, there we go. We repeat our request from 201B to say that operators are responsible for their contractors' compliance. This provides significant clarity and simplicity and in our opinion does not raise jurisdictional issues. In the 300 series, there's a number of requests from our previous submissions that we are repeating. I'm not going to read this whole slide to you. I will submit them if.
Ms. Burke, if I could, we don't see the 300 series slide. We still see the beginning.
Okay, can we stop? Let me close this and just start all over again.
Okay, we'll halt your time. Let's see if we're going.
Okay, now you go away. I don't know how to get rid of the notes screen. Well, at least can you see the main one now?
Yeah,
Okay.
we can now see the 300 series.
All right, we'll stick with that one. All right, so I'm not going to read it to you anyway, but that is a handful of requests in the 300 series. Okay. Now on the 301F3 pre-app, we are happy with this. We feel it'll add value in many cases, but we did notice a potential notice problem just for consideration. Because the operator is not required to apply to a local government first, the local government may not know far enough in advance that an OGDP is coming to the commission to timely request this pre-app. So we just suggested a notice addition to this to ensure that the local has the info they need to make that request. ALAs, 304B2 carries forward the concept that the director can decide during the completeness review that an ALA is not required for an OGDP, even if the criteria have been triggered. This is just too early in the process for a waiver. When determining only whether the OGDP package is complete, staff and the director can't reach a conclusion on the appropriateness of a location that's already been determined to be of some concern under the 304B criteria. So that conclusion really requires a full analysis. So we again ask that this particular exception be eliminated. The distance triggers for an ALA, we think should be larger than whatever the setback distance is that you land on for 604. Any location within that setback distance is already subject to significant scrutiny under 604. Yet, per this lot of evidence that you've already received, adverse impacts can still be experienced beyond whatever that setback number is liable to end up at. And therefore, we ask that ALA be required at a distance at least 500 feet greater than what the Rule 604 setback winds up with, okay? For caps, we continue to believe that caps are an extremely valuable planning tool, so much so that we continue to argue that you should take control over them and give yourselves the power to require them in the right circumstances. Rule 314 now uses the words encourage, request, discuss, and we suggest rather words like consult, determine, and where appropriate, require. Also in the cap rule, there's a new provision, and this is under preliminary siting authority, that talks about the operator telling you whether its plans are consistent with the local government's land use planning documents. And because the local government is meant to be a player throughout the process, we just request that you take that information from the local government on its own planning documents and not from the operator. And with that, I will turn it over to Elizabeth.
Thanks, Kate. Thanks, Commissioners. Elizabeth Prano speaking on behalf of the Affiliated Local Government Coalition and the City of Aurora with respect to all the rules here, other than the City of Aurora does not have a position on Rule 604B or Rule 423B2. So I just wanted to start with cumulative impacts analysis. We support the new rule that makes submission of a cumulative impact analysis plan mandatory. We think that's very important. We also heartily support the new emission requirements, quantification requirements with respect to both methane and HAPs, both for mobile sources and stationary sources. We do believe that the staff's proposed rules falls under the Clean Air Act's Indirect Source Review Program provision in Section 110A5 of the Clean Air Act, and is valid as the requirements apply to emissions for the entire oil and gas development plan as a whole, rather than solely regulating mobile source emissions as a separate direct source. Regarding the 400 series, we request that the notice before a shut-in well is returned to service be changed from 48 hours to 2 business days to avoid problems if notice is given on a Friday for a Sunday startup. With respect to the noise rule, Rule 423, the ALGC continues to urge the Commission to remove the provision that allows for increases in dBA and dBc noise levels during pre-production activities. You've heard a lot of testimony that that is the noisiest aspect of an oil and gas facility, and it does cause significant disturbance to nearby residents. With respect to lighting, we want to ensure that the standards are measurable and enforceable. We previously suggested an ongoing task force to explore this difficult area, and we urge the Commission to initiate that stakeholder or task force process. In the 500 series, we repeat our earlier request for elimination of Rule 525C4, which reduces the daily penalty amounts when a violation is of a longer duration. And with respect to Rule 604B, the ALGC supports a clear 2,000-foot setback from any residential building or high occupancy building unit. We understand the need for flexibility, and thus we agree that there should be a variance option at a hearing before the commission. However, we simply suggest, rather than there being an allowance for any exceptions without a hearing, that every single request for a facility to be located within 2,000 feet of a home or a high occupancy building unit goes before the commission for a hearing. So in our opinion, having that clear 2,000-foot setback eviscerates the need for the 500-foot setback. We simply think that is no longer valid now that the actual setback distance is 2,000 feet. And then lastly, Aurora and the ALGC supports this provision, continue to urge the commission to strengthen the groundwater monitoring requirements, both with respect to drilling a monitoring well anytime that the oil and gas facility is above a USDW aquifer, also drilling a superficial monitoring well to test for lower subsurface contamination, and requiring more frequent sampling after the stimulation occurs to ensure early detection of potential oil and gas contamination of an aquifer. Thank you. We are open for questions.
Thank you, panel, for your presentation. Ms. Burke, if you could stop sharing screen, we'll be able to see each other much better. Thank you. Ms. Paranos, I believe that Commissioner Putnam had to leave us for another meeting, and he's going to come back later. And I don't know if you were on the Zoom when he had questions for industry about to Mr. Neslin about the mobile information. Do you want to elaborate your perspective on that?
Yeah, I'm happy to. So the first thing is requiring, I would say two things. One, requiring that the operator submit data, which is basically an emissions estimate for mobile sources. We don't think necessarily is the same as requiring regulation of those sources. Certainly how that information is used potentially could result in regulation, but simply the pure requirement of asking the operator to estimate emissions so that the commission can get a more wholesale understanding of the potential air quality impacts from an oil and gas facility, in my opinion, is not the same as requiring control requirements. So that's one thing. Secondly, Commissioner Putnam referenced the San Joaquin Valley rule in that case, the San Joaquin Valley Air Pollution Control District promulgated a rule that applied to a facility as a whole, a construction site, I believe, or a larger facility. Within that facility as a whole, the operator had engines that were used to power construction equipment. Those engines are mobile sources. EPA does have exclusive authority to regulate mobile sources. California can obtain a waiver, but in any way. So what the court found in that case is that because the rule that was promulgated applied to the development site as a whole and basically required the operator to estimate emissions, just like here, that in that instance, that rule fell under the indirect source sort of exception in the Clean Air Act that does allow states to regulate indirect sources. And as a part of that, because the indirect source there was the site as a whole, not the specific engine at issue, the requirements that did require not only just an estimate of emissions, but would also potentially require the operator to make some changes to those engines to meet the emission standards that the San Joaquin Valley was regulating, fell under this indirect source review exception. So I think it's exactly parallel what the staff has proposed here.
Okay, so what staff has proposed, you would say we're good to go under current law?
Absolutely.
Okay. Then your suggestion about the 2,000-foot setback with hearing exceptions. So am I understanding that your clients would advocate that it's a 2,000-foot setback and that any exception would be through a hearing. And so what's your position relevant to the suggested off-ramps of surface owner consent or waiver or variance and informed consent?
I'm gonna let Kate Burke answer that one.
Ms. Burke.
I'll speak to that. So our position, is that landowners, of course, are free to make contracts regarding use of their property. However, it's common, well, it's not unusual for those rights to be somewhat restricted. I have property here. I'm not allowed to set up a concert venue or a racetrack or store hazardous waste on my property, and by way of a private contract that's regulated by the relevant agency. In this case, we believe that the same thing should apply. COGCC has, as we've discussed throughout this rulemaking so far, an independent duty to regulate protectively for public health, safety, welfare, and the environment and wildlife resources. So what our position is that if the landowner or resident of the building unit signs a waiver or enters a surface use agreement, that's fine and great, and that it comes to you at the variance hearing, and you then take that into consideration as part of the evidence of whether this site is going to be appropriate because it's less than 2,000 feet. And you have in today's draft, the term informed consent has been added in several places, and to make the determination that the consent is conformed is going to take some level of inquiry. So in our minds, you already need to look into that waiver and that agreement / consent anyway. And so our position is operator and probably landowner come for the variance hearing. If there's and then among all of the evidence, public health and otherwise, that you are considering at that variance hearing, you're also considering the landowner's agreement and giving it the weight that you find appropriate under the circumstances.
Okay, thank you for that.
If I might add to that, this is Kim Sanchez. I think that we recognize that this shift to not letting SUAs automatically, allow for an exception is significant. And to be honest, this issue became highlighted as we began to think, more about the well-meaninged idea behind informed consent. But from Boulder County's perspective, it comes down to a read of SB 181. So SB 181 requires you to protect and minimize adverse impacts to public health, safety, welfare, environment, and wildlife, not to protect and minimize unless you contract out of that and accept the public health or medical consequences of being closer. So while we recognize that there may be some circumstances where flexibility from a hard setback is necessary, we think that the SUA and those other reasons for closer location should be considerations and not automatic exceptions from the setback. So we're simply asking for your inquiry and scrutiny when considering an SUA, rather than accepting that as the automatic reason something should allow for a lesser setback.
Thank you, Ms. Sanchez, for that additional clarification. One other question or suggestion. Ms. Burke, as currently drafted, Rule 302E requires that 30 days before the OGDP is submitted that it is notified to the local government. Does that take care, I know it's not 60, but does that sort of take care of the issue you were concerned about?
Provisionally, yes. Honestly, when we read through that, it's very difficult to do the cross-referencing between the different sections. So the main thing that we were raising was the point to ensure that that notice is there. I think 30 days is sufficient. So if that's clear and clearly applies in that in that 301 F3 pre-app, then we'd be satisfied with that.
Thank you. Commissioner Messner, I believe you had raised your hand.
Thank you, Mr. Chair. I wanted to go back to the informed consent conversation and just ask a couple more questions to make sure that I'm understanding, because as written, if an operator was able to gain informed consent for an application, a sighting within 2,000 feet, then they would have to include that informed consent as a showing within their OGDP application, and therefore would get a public hearing as part of the OGDP review process in order to be able to make a finding that they were able to meet that standard. And so I guess my question is that not create the hearing that you're wanting to see?
Ms. Sanchez or Ms. Burke?
Yeah, I'm looking at the rule language. So I think there's two answers to that. One of them is, hold on, sorry. In what is right now 604A4, and this is the 500-foot setback. And it says no working pad surface will be located less than 500 feet unless there's a waiver with informed consent. And then there's 604B dealing with the more than 500 and less than 2,000 foot arena. So presumably, if I can waive out of 500 feet, I'm assuming I can also waive out of 700 feet. So this is part of why we suggest eliminating 604A4, because it's just confusing and we think unnecessary. So that's one of the reasons that the whole waiver issue had come to light. And then, hold on a second, where is the,
It should be 604B1, I think.
604B1. And I guess I see, then this might be a drafting issue. So 604B4 talks about a hearing. 604B1 doesn't say anything about a hearing that I am seeing, and maybe a.
But
I lost you.
You know, a finding within the standard oil and gas development plan application process that does require a hearing in front of the commission, and so would, you know, have that opportunity for a hearing in order to be able to affirm that they do have informed consent for 604B1, should they be interested in utilizing that off-ramp.
So I don't have a ready answer for this. This raises another thing that we've been tossing around is there's the OGDP hearing. There's a Rule 502 variance hearing. There's a 604B4 Rule 510 hearing in those circumstances, which, if nothing else, is very confusing and unclear to me. And I'm not sure if each of those hearings provides all of the same opportunities, the same the 604B4 lays out some very specific considerations. So I don't know that I can answer for you which one of those types of hearings we find to be the most appropriate in the circumstances. One of our overall themes with this rule is simplicity, because it is very complicated. So if there were certainty that 604B1 waiver and the informed consent aspect of it were clearly in front of you with the opportunity for all the necessary stakeholders, and it's under 302 versus 510 versus 604, we want to be sure that occurs. And honestly, we would recommend some kind of streamlining of all these different hearings that are mentioned. I don't know if that helps.
No, thank you. I appreciate that. And I'll ask questions during deliberation and chat through that so that hopefully we all have clarity on that.
Hmm.
Other questions from the panel or to the panel from the commission? Yeah, I guess I just a comment, and maybe I should wait for deliberation, but I think that as many of the things that we're doing in enacting policy around implementing 181 is looking at different rights, and I think that staff, and I think that we have recognized with the current draft the right of the surface owner to make decisions about the use of surface relevant to oil and gas operations. I think that is something that we have been trying to recognize. And so appreciate your comments, appreciate the comments from the panel. We'll certainly get into deliberations around these issues, and have appreciated the contributions from the affiliated local government coalition to this rulemaking. It's been very helpful for us. So thank you very much.
Thank you.
Thank you.
With that, I'm looking at my cheat sheet. It looks like we have the wildlife hunting and angling groups up next. Maybe we'll do one more panel and then take our morning break, perhaps. Good morning, Mr. Randall. Are you presenting this morning?
Good morning, I am. Can you hear me all right?
We can.
Great. Thank you. First, just one housekeeping matter. We proposed to Hearings Manager Larson that we would cede 1 minute of our 3 to the environmental groups. We never got confirmation of that, but I just wanted to say, okay, good. I'm planning to take 2 minutes.
You have 2 minutes once you get started.
Super. Good morning, and thank you for the opportunity to provide this closing statement. I first just want to express my appreciation to Director Murphy, Chairman Robbins, and each of the commissioners for your dedication to listening to all 90+ parties, to working through the myriad complex issues that you have before you, and for implementing the new mission provided by the General Assembly. I know this isn't easy, even if it's your full-time job, so thank you very much. The wildlife hunting and angling groups generally support the proposed revisions to Rules 303 and 304 addressing cumulative impacts. There are 2 matters I'd like to discuss briefly. First, staff proposes to excuse an operator's analysis of several wildlife-related resources in its Form 2B CITER submittal, including habitat fragmentation, habitat loss, seasonal habitats, migratory corridors, and flyways. We object to the exclusion of these important wildlife factors or habitat types. In its place, staff would require the operator to submit only a list of high-priority habitats within 1 mile, number of acres to be disturbed within high-priority habitats, and current land uses. This would excuse the operator from conducting any analysis whatsoever of how important wildlife habitats would experience cumulative impacts from the proposed development. We request that the Commission revert to the original rule language for this section, and this is in Draft Rule 303A5 Big C, Romanet 4, BBFF. Second, we support staff's proposal to require operators to identify past, present, and reasonably foreseeable oil and gas and other industrial development taking place nearby. This information provides vital context for a cumulative impacts analysis and a plan to address cumulative impacts. We urge the Commission, however, not to limit this information to activities occurring only within 1 mile of the proposed location. Not only do wildlife range significantly farther than 1 mile, but they can be impacted by activities occurring more than 1 mile away. We suggest you adopt a standard similar to that used by federal agencies, where they consider any past or present actions reasonably expected to result in cumulative impacts when added to the proposed action. This is in Draft Rule 303A5 Big C. Again, thank you for your time this morning, and thank you for your service to the people of Colorado.
Thank you for your closing and for your written submittal. Do we have questions? Commissioner McGowan.
Thank you, Mr. Chair. Thanks for your testimony. I'm wondering if you could clarify, if we were to use something similar to the federal language, how does the operator determine a catchment area? That's the only word I can think of for how they come up with an analysis for impact. Like that language seems rather broad, and then it seems like then it's up to the operator to figure out how big of an area to consider for impacts.
Yeah. Thank you, Chairman, Commissioner McGowan. It is a subjective standard, and it is what is reasonably expected to have cumulative impacts when added to the proposed action. Admittedly, a bright line like a 1 mile boundary is cleaner and perhaps simpler, but we think that it's less likely to yield information that would be useful to the Commission in evaluating the cumulative impacts of a project. And I guess I would submit that there is a large sort of body of practice and jurisprudence around what reasonably foreseeable cumulative impacts are, from which the Commission and parties could draw in implementing a rule as we've urged. I would submit that oil and gas operators are no strangers to this process, especially those who have done business on public lands or developing federal minerals, either in Colorado or elsewhere in the country.
Further questions for this panel? Great. Thank you, Mr. Randall. We have appreciated your client's participation, and we thank you for your closing. With that, commissioners, do we want to take our morning break for 10, 15 minutes thereabouts? Okay, let's return at 10:45, and then we will take up the remainder of closing statements. Started again with the closing statements from parties in the Colorado Oil and Gas Conservation Commission's Series 200 through 600 mission change rulemaking. With that, I believe we are now teeing up battlement concerned citizens and others. I see Mr. Sura has joined us, and perhaps we have Mr. Samuelson as well.
Me today.
Okay, we just have Mr. Sura. You have, I believe, 6 minutes. Take it away.
Yeah, it should be 8 minutes, but do you see my screen?
We do see your screen.
Okay, thank you.
Ms. Larson, or is it 6 minutes or 8 minutes? Just get our timing down.
Yeah.
Excuse me, I'm sorry, I was still on mute. Yes, it is 8 minutes. It was a last minute change.
Okay, thank you. Good morning. Matt Sura here for Battlement Concerned Citizens, Conservation Colorado, Grand Valley Citizens Alliance, and Western Colorado Alliance. First, I'd like to thank the COGC staff and you commissioners for the incredible work that has occurred. The changes you proposed and championed will make a huge difference in how oil and gas development occurs in Colorado. The rules in the 200 to 600 series embrace the new mission of the Colorado Oil and Gas Conservation Commission as set out in Senate Bill 181. First, we want to thank you for your commitment to good process. The rules for notice, standing, local public hearing, and variances will ensure that the public is notified and will allow adversely impacted people to speak directly to you, the decision makers, which will lead to more informed and more just decisions. We also appreciate your commitment to water quality protection and encouraging water recycling. We thank you for your attention to disproportionately impacted communities. And finally, I'd like to thank you for your commitment to public health, safety, welfare, and the environment. In our closing, we want to focus on siting. We support requiring the alternative location analysis to match the setback distances, except in one important case, the disproportionately impacted communities. As written, the alternative location analysis trigger for a disproportionately impacted community is the same as for any other community, 2,000 feet from a home or school. In an effort to avoid targeting disproportionately impacted communities for oil and gas development, we are encouraging a requirement that the trigger for an alternative location analysis be increased to 2640 or half a mile from a home or school within a disproportionately impacted community. We also request that the director be prohibited from waiving an alternative location analysis if it is triggered because of a proximity to a disproportionately impacted community. Moving to setbacks, we agree that there are some issues that can be mitigated by best management practices and better technologies, and setbacks is a blunt tool, but it is also by far the most effective way to avoid impacts to public health, safety, welfare, the environment. The industry is requesting that you ignore the 2019 CDPHE health risk assessment that monitored high levels of benzene, ethyltoluene, and toluene during drilling completions and early production, and use modeling to determine that acute health effects could occur as far as 2,000 feet away. Industry is also asking you to ignore the subsequent high readings of benzene that were recorded by the state last year outside an elementary school, and another recorded by a third-party monitor in Broomfield. It would also have you ignore the hundreds of complaints of health concerns received by the Colorado Oil and Gas Conservation Commission and CDPHE Health Information Line that the state toxicologist believes are consistent with high levels of hazardous air pollutants. Instead, they have offered not peer-reviewed studies, but assurances that they have been doing their own monitoring and they have not found any benzene. Moving to safety, the industry has offered no alternatives as to how they can assure no fires or explosions will occur. They have not disputed this peer-reviewed study that states that fire and explosions occur in Colorado at a rate of at least once a month. Industry has offered no technological fix that can prevent all blowouts, fires, and explosions. Requiring an emergency evacuation plan is important, but it does not prevent impacts to public safety. It only plans for how to respond when an emergency occurs. As was stated in this peer-reviewed study, a 1,500-foot setback is inadequate to protect public health and safety in the event of an emergency. We appreciate that the staff has proposed lower C-scale noise limits in line with the leading health research. However, the proposed rules will still allow 10 decibels more noise during drilling and completion operations. This is a doubling of noise levels. As we have shown, a doubling of the distance of a pad to a receptor decreases noise by 6 decibels. The oil and gas industry should be able to meet residential noise limits even during drilling and completions if they are at least 2,000 feet away from homes. Last week, the staff proposed setback language with 3 main off-ramps: informed consent waiver, demonstration that protections are substantially equivalent to those of a 2,000-foot setback, and a comprehensive area plan. First, we believe that informed consent used in Rule 604 should be defined. Landmen in the oil and gas field are paid professionals. They're very good at what they do. They spend every day convincing people to lease their minerals or to sign surface use agreements, pipeline easements, or waivers. In Battlement Mesa, a company was able to convince 6 families to sign waivers to allow a multi-well pad within 360 feet from their homes. Having talked to them personally, many had only a vague idea of what was being proposed, and that they were offered $400, the equivalent of 1 month's rent for their mobile home lot. Many did not speak English, but the waiver they all signed was in English. That is not informed consent. We are offering the following definition of informed consent for the 100 series. This definition is comparable to the duty a physician has to their patients or an attorney has to clients to inform them about their options and the consequences and potential risks of a decision. Without a strong informed consent provision, we agree with the allied local governments that allowing an operator to use waivers for a proposal closer than 2,000 feet should be eliminated. The most important off-ramp is a hearing for the full commission to consider whether the proposed conditions of approval, technologies, and design are sufficient to provide protections for public health, safety, welfare that are substantially equivalent to those achieved by a 2,000-foot setback. Because this is the standard that is going to drive what mitigations are necessary and whether a location can be approved or denied, it must be clear. For example, wildlife protections is important, of course, but it is not the purpose of a residential setback. We encourage you to consider this clarifying language. We've also offered these other changes that we believe are self-explanatory and are needed for clarity. Finally, if the location is part of a comprehensive area plan, the same substantially equivalent standard should apply there as well. In our written statement, we have also noticed that preliminary siting decisions have been added to comprehensive area plans, which is a change we support. So long as the residents within 2,000 feet are notified, have an opportunity for consultation, and have automatic standing to appeal a director's recommendation to the commission. We believe that this was an oversight that should be corrected. In closing, we want to thank all the parties to this rulemaking. Every party has worked hard to find workable solutions, and as a result, we have achieved a lot of agreement throughout this rulemaking. Thank you.
Thank you, Mr. Sura. Thank you for unsharing your screen. Do we have questions? Commissioner McGowan.
Thank you, Mr. Chair. Mr. Sura, going back to the definition that you all provided in your written testimony and today, if the definition for substantially equivalent is as if someone were 2,000 feet away, I think the point that industry made is things like the nuisance issues that we have, noise, odor, light. Probably you could never say at 1,500 feet it's going to be the same as if I were 2,000 feet away. And so are we creating then a situation where someone who wants to use one of the off ramps could never be successful? And I'm wondering what your thoughts are about that.
Yeah, thank you so much for the question. Absolutely not. I believe that it is going to allow for appropriate mitigations depending on all those considerations that you're already looking at. The size of the location, what kind of oil and gas development is being proposed, and the proximity to the homes. I mean, if you've got a location that is proposed 1,800 feet from a residential neighborhood, as an example, that location is going to have a much easier job working through noise issues, lighting issues, and any odor issues, all of those nuisance issues that were mentioned. And I believe, would, with additional mitigation measures, be able to get that approved. However, if it is a location for, say, 24 wells within 700 feet of a neighborhood, it's going to be a lot harder for them to meet those requirements. And it should be, frankly, because there's going to be a tremendous amount of time that those neighbors are exposed to all those nuisance and health and safety issues. And they should be required to either be at a higher level or they don't get approval and they have to find another location that's more appropriate.
Any follow-up, Commissioner McGowan? Commissioner Messner.
Thank you, Mr. Chair. I wanted to just follow up on that one a little bit. So substantially equivalent to 2,000 feet, and I'm talking specifically to the two prescriptive standards, the nuisance standards, and that's lighting and noise, where we've got fairly measurable standards that would be required to be met. How do you know what the noise is going to be for an operation at 2,000 feet in order to determine that it is going to be substantially equivalent to that in a couple of prescriptive standards, right? Rather than just saying that they have to meet the standard.
Yeah, thank you for the question. So the example of noise is a good one. There are requirements in the existing regulations that require them to meet a certain standard, both 350 feet away from the noise source as well as from the receptor. And because noise, and I think that Dave Neslin actually said that nuisance is attenuated with distance, and he's exactly right. Every time you double the distance, you are going to decrease noise by 6 decibels. And so it becomes kind of a math problem in some respects, in that you can have certainly a nuisance issue at 350 feet, but if the receptor is 2,000 feet, they are not going to be experiencing that same level of industrial noise. And therefore, the exception allowing for the doubling of noise during the drilling and completion is almost unnecessary, because that is attenuated by the distance. I hope that answers your question. And if it doesn't, I'd like to try to get another shot at it.
No, that's all right. I'm gonna, it didn't quite, because I think where I'm struggling with is, I understand the intent. I understand that trying to make clarity as far as being substantially equivalent to 2,000 feet, I think I struggle with the noise and the lighting piece as far as determining what the noise it would be. Let's just give a for example. So let's assume that the noise at 2,000 feet is 25 decibels to the receptor, and I want to have my working pad surface at 1,500 feet. Do I have to make the noise at 25 decibels in order to meet the 2,000 foot standard? Or do I just need to meet the standard, which, without looking at it, I believe would be, 50 decibels or 55 decibels, depending on time of day?
Yeah, in that case, it would be that they would need to meet the residential standard. However, in that instance, they would not have to meet the residential standard 350 feet, as is required by your rules. That standard could still be 10 decibels over what is the residential standard while during drilling and completion. But once you get to the residents themselves, they should be living with residential noise levels rather than industrial noise levels. And lighting is something that is also something that I've seen personally that the industry is able to address. They have the ability to take pictures, or even have people that are complainants take pictures of, the rig, and be able to tell them exactly which light needs to be directed more downward, so they don't experience that nuisance. This is not something that.
No, I appreciate that. I'm not saying my question correctly, I don't think, because I'm actually talking about 604B, and I'm talking about the substantially equivalent, and I'm talking about, substantially equivalent to the 2,000 foot setback as an off ramp in order to be able to have it sited within the 2,000 feet. And so I guess my question is, first of all, how do you determine what the noise is at 2,000 feet without having the operation there? And then how do you is your expectation that the operator meet whatever noise there may be at 2,000 feet to the receptor, or do they just need to meet or be at or less decibels than the standard in a noise circumstance within that 2,000 feet in order to be able to potentially utilize that off ramp? Am I making any sense?
Yeah, you are. Just to back up, the industry has offered that the standard should be protection of public health, safety, welfare, and the environment. And we respectfully disagree based on the fact that that is the standard for all oil and gas development. And this doesn't require them to make any findings other than what they have to show for every oil and gas development, and it frankly would be a meaningless setback. So requiring some sort of showing that they are going above and beyond and looking at the impacts of that oil and gas development and trying to determine how they can eliminate, if possible, impacts to noise by meeting, in my estimation, it should be a residential noise level. If there's a residence that is 2,000 feet away, there's no reason that they should be experiencing anything more than residential noise from that oil and gas facility. Similarly, they shouldn't be experiencing any odors. And if they are, those are issues that need to be mitigated. I would say that, it comes down to, in large part, eliminating much of that nuisance that, is very specific to oil and gas development, to the extent that it's possible. Obviously, even if you're 2,000 feet away, there's still going to be a hum from any industrial noise. You're still going to see a light off in the distance, but it's not something that is going to be keeping you up at night.
Okay, thank you.
Commissioner Gonzalez.
Thank you, Mr. Chair. Thank you, Mr. Serra, for your testimony. I want to kind of align some of the things we've heard today. Is it my understanding that that in your estimation, there can be operations within 2,000 feet that are protective of public health, welfare, safety, the environment, and wildlife resources?
Yes.
Okay. And then I want to clarify another thing. Is your suggestion that the standard for which we evaluate operations in Colorado, regardless of the scenario, that it should exceed that standard of protect, minimize adverse impacts, public health, welfare, safety of the environment, wildlife resources?
It doesn't need to exceed it. It's just that there are certain things that can only be met by distance. Protection for public health and safety, specifically explosions and those types of issues. There is a certain blast radius that you need to be away from an oil and gas facility. An oil and gas facility that has, say, 15 tanks filled with hydrocarbons is an explosive risk, and therefore you would expect that there's going to be, for safety concerns, a greater setback from homes for that facility than one that has no tanks on site and everything is piped. So yeah, my sense is that we are trying to keep residential areas residential. And this is the one industry, that we have historically allowed for a heavy industrial facility to be located, frankly, anywhere that they wanted to go, including in the middle of residential areas. And if they can't meet that residential standard and allow for the person living in their house to experience their home the way that they bought it and the way that they expected to live in some semblance of peace and residential noise and light, and not in an industrial area, then the oil and gas industry doesn't belong there.
And so with the protections that we've kind of put in place with the 400 series and the lighting and noise requirements, are those not protective enough?
Well, the requirements that you have in place right now allow for a doubling of noise during drilling and completions, as an example, including in a residential area. And those receptors would be experiencing something closer to industrial level noise than residential noise. And yeah, I don't believe that they should have to endure that. And a setback does attenuate that, it eliminates it. And if the oil and gas industry can eliminate that noise, then they can be somewhat closer, at least when looking at that one issue. I think you also have to look at the type of operations that they have, the amount of emissions that they're producing, some of the cumulative effects analysis. All that has to be part of what you're looking at in determining appropriate distance.
Yeah, and I think that all should be looked at when determining appropriate distance. So I appreciate the testimony. Can I ask you about blast radius? So I don't recall if I saw what that radius looks like on a per tank basis, or how you extrapolate that, and what information has been gathered to determine that. I'm curious about how that looks.
Yeah, so this is something that was put into the record by the community groups. We have also referenced it several times. It's called Adequacy of Current State Setbacks for Directional High Volume Hydraulic Fracturing in Marcellus, Barnett, and Niobrara Shale Plays. The lead author is Haley. It was published in 2016. And they looked at blast radius, thermal modeling, vapor cloud modeling, and air pollution data that indicated that a 1,500-foot setback in some of the instances and emergencies that frankly are just a part of any industrial operation, not singling out the oil and gas industry at all, but any heavy industrial operation is typically cited in an industrial area for this very reason, because they can be dangerous when things go wrong. And you can have all the rules in the world and you can have a perfect model operator, and still things can go wrong. Lightning strikes, a piece of equipment breaks. There's human error. All of these things have been documented in the cause of the average of one explosion or fire a month that was put forward in the Blair paper, was also submitted into the record. Those things can't necessarily, be controlled by rules. And that's another good example of where distance is really the only way to adequately protect public health and safety.
I will look to those studies and try and figure out what they're modeling. I imagine with the prevalence of explosions as you testified to today, that there's probably some actuals in there that would tell us what the radius is and what the actual impact is. Is that in those studies as well?
Yeah, it is in there. And I'm sorry that I don't have the study in front of me that I can point to, but I'm happy to send you the study if you'd like.
I'll pull it from the record.
It's in the record.
Other questions for this panel? All right, seeing none, thank you very much. Appreciate your closing statement today and your participation. On behalf of your clients, we now move to environmental groups / citizen groups. And Mr. Freeman, I believe, is going to run lead.
Good morning. Can you see me?
We can see you.
Great. And I would also like to share my screen if that's possible.
It should be.
No. All right. So I'm ready to go. I believe I have 9 minutes. Is that correct?
That is accurate.
Great. Thank you. Good morning. My name is Michael Freeman again. I represent the environmental groups. And first, I'd like to thank the commission staff and the commissioners for all the work you've done and the consideration you've given to the party filings throughout these hearings. I'll be focusing this morning on proposed Rule 604 and the setback issue. First, you've heard a lot over the past couple of weeks from the industry parties asserting that adopting a 2,000-foot setback would be arbitrary and capricious and just not supported by the record. And that's simply not accurate. The record from these hearings amply supports a setback of 2,000 feet and even a much larger distance than that. As the staff recognized, there are numerous scientific studies, literally dozens of them, that have found impacts out to distances well beyond 2,000 feet. In those studies, moreover, are backed up by hundreds of citizen complaints involving symptoms that closely match what you would expect from exposure to benzene and other air toxics from oil and gas development. And third, the commission staff found, and there's a substantial testimony and evidence in the record from these hearings, that a 2,000-foot setback provides a valuable tool to minimize noise impacts, accidents and explosion risks, and other nuisance impacts. Contrary to the arguments you've heard from the industry parties, this commission is not required to accept the industry's view of the scientific evidence. As Leanne Hill and Carol Kwiatkowski described, there's a large and growing body of literature in the record supporting the likelihood of acute risks and adverse health outcomes at 2,000 feet and beyond. Unlike industry's testimony, those studies have been subject to peer review, and we think the commission should look to that full body of literature rather than the arguments by industry's hired experts. And at bottom, it's just black letter law that this commission's finding on a factual issue like this one, with support in the record, will get deference even if the industry disagrees with it. Moreover, a 2,000-foot setback is especially appropriate in light of this commission's new statutory mission. SB 181 directs the commission to ensure protection of public health, welfare, safety, and the environment, and to require that where it occurs, oil and gas development is done subject to that protection. So even if there are remaining scientific questions, it's entirely appropriate and entirely legal for this commission to err on the side of being more protective rather than less protective when adopting a setback. Now, while the 2,000-foot setback is appropriate, the exceptions that were written into last week's draft, we think, and we're concerned, threaten to undercut the entire purpose of establishing a larger setback. To be effective, Rule 604 needs to set clear standards that operators know they'll need to comply with when they're planning projects and acquiring mineral rights. And to protect the public, Rule 604 also needs to establish the same kind of bright line. Rule 604 won't provide that kind of protection if operators can routinely propose shorter distances based on site-specific mitigation measures. A major part of why setbacks are so important for the public is that residents are invariably at a major disadvantage during project level or permit specific review. At the permitting stage in the process, the operator will be the one doing the alternative location analysis, not an impartial third party. And at that stage, the operator has already acquired the minerals and presumably entered into surface use agreements that foreclose other alternatives and options for reasonable locations and approaches. And more broadly, the operator will almost always have greater information than the residents about its own operations, the likely impacts from those operations, as well as available mitigation options. So trying to address this solely at the permit review level is just not a level playing field, and it's not a substitute for a strong, robust setback. Now, there are a number of different ways to strengthen the 604 language, and we support the proposals to simplify it and go with a hard 2,000-foot setback that were suggested by the affiliated local governments and others. But if the commission's working from last week's language, we suggest one option here to, I think, tighten up Rule 604B. And that would be in 604B4, where the operator is asking for an exception, it must first, A, demonstrate that compliance with the 2,000-foot setback is infeasible, and B, that the operator has made a reasonable effort to reach an agreement with affected residents on a waiver. With that approach, if the operator wants to go closer than 2,000 feet, it has to show that it can't comply with the setback, and it has to engage with the neighbors and try and work out a resolution with them, rather than running roughshod over the neighbors' interests. That approach would be much fairer to the nearby residents and will also allow them to protect their own interests much more effectively than a permitting review. In addition, also in 604B, we strongly object to the industry party's argument to require anything less than a substantially equivalent standard. We think for all the reasons above, there needs to be an elevated standard for any exceptions to the 2,000-foot setback. It can't simply be a protect and minimize standard. And we urge the commission to slightly clarify the language to make clear that what substantially equivalent requires is protections equivalent to compliance with the 2,000-foot distance. In addition, we'd also like to address briefly an issue related to impacts on operators from the 2,000-foot setback. A couple of weeks ago, you saw some map suggesting that a 2,000-foot setback would eliminate virtually all development in Garfield County. That didn't sound right to us, so we went back and ran our own GIS analysis, and that analysis found a much more limited impact in Garfield County. Now, the numbers on this slide overstate the impact of a Rule 604 setback. Our analysis had to use a data layer that includes all addresses, not just residential buildings. So the numbers here cover both industrial and commercial and other buildings as well as homes. So in reality, the number of wells affected by Rule 604 will be considerably lower than what we found from this analysis. But what we found is that most existing wells in Garfield County, nearly 2/3 of them, would not be affected by a 2,000-foot setback at all because they're farther removed from any buildings. And as this map indicates, there are many wells that are within a 2,000-foot buffer, but are right on the edge of that buffer. And that mapping suggests that it would have been feasible for many of these affected wells to have actually complied with a 2,000-foot setback. What our analysis also found is that given the lower density of buildings in Western Colorado, most of those wells that were close to buildings affected only a small number of buildings. And we think that's significant because it suggests that where operators believe that complying with a setback is infeasible, it's realistic to require them to attempt to negotiate an agreement with the affected residents. As I said a moment ago, we think operators should be required to try and work the issue out with the residents and the neighbors before asking the commission to exempt them from the 2,000-foot setback. Here, though, I think informed consent is really critical. The residents need to have access to adequate information in order to meaningfully engage with the operator. And we support the proposal of Battlement Concerned Citizens on this issue. The residents should be provided information on what's being proposed, and the residents should have an opportunity to meet with commission staff about the operator's proposal. That kind of a meeting with commission staff would provide a really valuable source of impartial information for the nearby residents. And we think making staff available this way at the front end of the process would likely save the commission time and resources over the longer term, where operators and residents can reach an agreement that's fair to both sides. Finally, even if operators aren't drilling 2 to 3 mile horizontal wells in Garfield County, the same way they are in eastern Colorado, the commission's database shows that operators in Garfield County are routinely drilling 3,000 feet directionally, which is of course well over the 2,000-foot setback we're discussing. And I think so in Garfield County, as in northeastern Colorado, the operators do have the ability to use directional horizontal drilling to give them some flexibility in addressing the setbacks. And then finally, quickly, I'd just like to touch on one issue, and that was the objection of industry parties to the automatic standing provision in Rule 507. We think that's kind of a remarkable argument for them to make. Essentially, the industry parties are contending that they should be allowed to seek an exception from the protective setback, but also try to prevent the affected residents and the affected neighbors from even being a party to that process. As I've said, exceptions to the setback should be approved rarely, if ever, but if they are considered, the residents need to have a seat at the table. And the 507A language does not conflict with the APA. The commission has the authority to adopt its own rules to implement the APA statutory standard. And we note on that score that the commission's rules already grant automatic standing for certain parties like government agencies and some other individuals in certain matters. So there's really no legal reason why the commission can't also do the same thing for affected residents. Thank you, and I'd be happy to take any questions.
Thank you, Mr. Freeman, for that summation and closing. Do we have questions for Mr. Freeman? Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you, Mr. Freeman. I appreciate your testimony, and in particular the map, because that was something that I had also asked for additional information in the intervening days, and we may also see some in some of the other closing statements. But I think, you know, view scale when you're looking at GIS maps is everything. And that was what occurred to me later. And so I wanted to look at a closer scale. And I think what you're showing demonstrates what I was wondering, but I just wanted to get clarification. So when you said, given that your analysis included all of the buildings because you couldn't, you know, limit it to the residential buildings, you said even in that case, is this correct, that 51% of the wells, of the existing wells were, there would only be 4 or fewer that would have been affected that may not have been able to be located because of this buffer, is that correct?
Sure, let me, if I could, I'll share my screen, maybe I can help clarify that.
Sure.
Can you see that?
Yes.
Yes.
Okay, so what our analysis did was we mapped existing wells in Garfield County, all active wells, against a 2,000-foot buffer from any address listed in the data set. And that there's a total there of just over 11,000 wells in the county. Of those, about 65% or 7,200 were just outside the buffers altogether, not affected at all. Of the 3,800 or so that were within the 2,000-foot buffer, a little over half of those, about 1,974, were within a buffer that was the buffer from either 4 addresses or 1 address or any, some small number of addresses. That doesn't include the wells that were outside of them altogether, just the ones that were affecting homes. And again, of that same 3,800, about 3/4 or 72% were within the buffer of 9 or fewer buildings. So more, but still not equivalent to trying to develop in the middle of a subdivision, basically. Does that answer the question?
Yes, thank you, Mr. Freeman. Yeah, so what you are showing there is that there would be a relatively small number of residential units from which to obtain the informed consent. Is that correct?
Exactly.
Okay. And then the other question I had is, you mentioned that you found that 3,000 feet has been routine and directional drilling. Am I correct in understanding that's the distance from the wellhead to the well completion, not the horizontal distance on the surface, or did you look at that as well?
No, when I say 3,000, I'm referring to the horizontal distance on the surface. So kind of as the crow flies. What it looks like is pretty common in Garfield County is they're targeting tight gas sand formations. And so they're doing kind of an S-shaped directional drilling wellbore. And the actual wellbore, I'm sure, is considerably longer than 3,000 feet. When I say 3,000 feet, it's as if you were just measuring the surface distance laterally, which is, I think, the relevant measurement for evaluating a setback.
Thank you very much.
Other questions for Mr. Freeman? Okay, thank you for your closing, Mr. Freeman, on behalf of your clients. We appreciate that. We will zoom you away and bring in, I believe Commerce City is next. Hello, Mr. Sura. Are you presenting?
Yeah, just briefly. Good morning, commissioners. Commerce City just wants to thank the commission for allowing it to participate in this rulemaking, and we reiterate the position we've taken earlier that broad use of an alternative location analysis, similar to the approach that is used by Adams County. Commerce City has found that alternative location analysis is an important tool, and it is probably the best way to find the appropriate location or the best location for oil and gas development. Happy to answer any questions.
Thank you. Are there questions? Commissioner McGowan.
Thank you, Mr. Chair. Sorry, I'm trying to remember from the written testimony. Did Commerce City, were they one of the ones who wanted a minimum number of ALAs to be required, or were they one of the folks who wanted an ALA to be required even if an operator is beyond the 2,000 feet or whatever setback level would be chosen?
Yeah, the answer to that is both. That was what they asked for, because the reality is that when you get it in an area as complicated as drilling within a municipality, and we gave a little bit of background on this when we were talking through the 300 series, but looking at Commerce City and trying to put together a patchwork that is going to work for development of all the minerals, but also protect public health, safety, welfare, and the environment, required an alternative location analysis that was holistic in its approach, almost like a comprehensive area plan. And we couldn't have found the locations that we did without looking at every location and clearly evaluating all the differing values, both existing uses, but also putting on top of that future land uses that the Commerce City is most concerned about.
Commissioner McGowan, for a follow-up.
Thank you. Just to clarify for myself, there's nothing in the current rules that would prevent a local government from saying, we want you to provide at least 3 additional locations and or look at this larger setback area for alternative location analysis?
That's correct. It's trying to ensure that, you know, that there's consistency in the regulations. There's also obviously a concern when you're getting into a municipality that's surrounded by different local government jurisdiction on all sides, where, you know, you would want some consistency in the application. You know, on one side they're bordered by Thornton, and another side Brighton, and another side Adams County. So some consistency would be helpful. And the idea that at least 3 locations are required, that's something that is a requirement in Adams County. Commerce City is actually looking at making that an expectation, but not a requirement, and then just giving, you know, an opportunity for the operator to give an explanation as to why they couldn't find 3 alternative locations.
Other questions? Commissioner Messner.
Thank you, Mr. Chair. This is more of a comment than a question, but, you know, as I still am going through all of this information and thinking about ALAs, I do think that that presentation that was given on Commerce City's process is still a very strong one as far as the benchmark of what ALAs look like and how that process can really be successful. So, so that's my comment. I really still do appreciate that visual as I'm thinking through, you know, ALAs and how they can be utilized very successfully. So.
Thank you for that.
Great. Thank you for your presentation. We will zoom you away and bring our next panel. Looks like the next 2 or 3 donated times to others, and so we're to CHC. Oh, I take it back. Ms. Kelly, sorry. Climate reality, you reserved 1 minute, I believe. And you're on mute.
Yes, we did reserve 1 minute. I'm just going to share a screen for just a second here.
Okay.
Can you see my screen?
We cannot.
Shoot. Okay, let's see what I did wrong. Perhaps I'm not being permitted to, oh, here we go. Okay, sorry about that, everybody. Can you see my screen now?
We can.
Okay, great. Okay, just so real quickly, we only have a minute here. Let me just say that climate reality, as we outlined in our closing statement, disagrees with certain of the 604B exceptions. I don't have time to go into that at any kind of length, but let me just briefly mention that the fact that operators plan to meet or meet with residents should not weigh in their favor as a consideration for shortening setbacks. That's something they should do as a matter of course. With respect to best management practices, preferred control technologies, and conditions of approval, that should only permit an exception to a setback when it avoids adverse impacts, not when it just minimizes or mitigates it, or else you're not doing that public health warranted setback. We really appreciate all of the hard work of all the commissioners, and we've really enjoyed this process. We do want to sort of emphasize at this point that birds are literally falling from the sky. You know, climate change consequences are happening now, as you are all well aware, and now is the time to take some serious action. So thank you very much.
Thank you, Ms. Kelly, for your presentation. If you could stop sharing your screen, we'll be able to see everybody a little bit better.
There you go.
Do we have questions for Ms. Kelly? Not seeing any. We thank you very much. And let's go to Ms. Natasha Legere and CHC.
Good morning, commissioners. Can you hear me?
We can hear you.
Wonderful. Actually, Chris Michalski will be presenting for us this morning.
Good morning, commissioners. CSU first wants to thank the commission and staff for the work done thus far in the mission change rulemaking to fulfill the mandate of SB 181. However, CHC has identified 4 areas in the latest staff revision that fall short of that mandate. First, denial of an oil and gas operation must be mandatory if the operation will violate the rules or the act. SB 181 requires this commission to protect public health and the environment, and discretionary denial if an operation results in harm to public health or the environment is an express violation of SB 181, as it can lead to approval of an application with adverse impacts. We are frankly confused at the resistance to mandatory denial for non-compliance with the rules. Second, water rights are property rights, and water rights holders must be able to receive notification of an oil and gas application. The commission discussed and seemingly agreed upon extending the 500 series general email notification list to the 300 series application process, but the staff revisions do not do so. Third, there must be some level of visibility into actions of contractors and subcontractors, and a level of oversight into their actions. Rule 201 needs to be amended to provide that contractors and subcontractors must comply with the rules, and the operator is responsible for their actions. Finally, and most importantly to CHC, is a lack of protection for off-site, meaning off the well pad, impacts from geologic hazards. CHC appreciates staff's efforts to increase transparency into their internal process and require a geohazard plan to mitigate geologic hazards. However, that alone does not solve the problems that we brought to your attention during the 300 series. It does not solve terra ditches concerns that induced seismicity caused by a horizontal wellbore more than 1 mile from the well pad could destabilize the precarious geology currently supporting the ditch, which is several miles away. It also does not solve the problems addressed by Dr. David No, that staff's current internal process is inadequate, which is supported by 30 leading geologists in a letter dated September 4th. Requiring a geologic map while creating transparency only codifies a substandard process. As you have seen, most geologic maps contain a disclaimer or a limitation that they are not to be used for a site-specific assessment of specific on-the-ground geologic hazards. That is, there's no magical map that will identify the on-the-ground geologic hazards. The proposed rule fails to protect terra ditch and others in such a geohazard situation. The commission must take responsibility for the fact that oil and gas operations have not undergone adequate geologic review to date, as stated by 30 of the leading geologists and geotechnical engineers. While we recognize the direction you gave staff, we do not see how the recommendations address the geohazard problem brought to your attention. An adequate process must be implemented to meet the standards of SB 181. I'll conclude with 4 questions to the commission. First, how do you reconcile mandatory denial for wastewater injection in the 800 series, but not for oil and gas operations in the 300 series? Second, why is an email notification list only available for a hearing, but not a permit application? Third, why is the lack of visibility into contractors and subcontractors deemed to satisfy SB 181? And finally, how does staff's proposed geologic hazard amendments solve the problem that their current process is inadequate? Thank you.
Thank you for that presentation. Commissioners, do we have questions for this panel? Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you both for your for the testimony. In the event of a denial, as you are suggesting, Is there an opportunity to cure, to reapply in your mind?
If the denial is based on a geologic hazard, is that the question?
Just, and you were just discussing in terms of the operations and that a denial would be mandatory if something was in violation. Is there an opportunity, would there be an opportunity to cure and to resubmit an application in your mind, in your view of when a denial occurs?
I believe so. I believe the rules state that they can appeal under the 500 series. So that would be one opportunity to cure. And our main concern is that if an operation does not comply with the rules, then there shouldn't be leeway for it to still be approved, because then it is an express violation of SB 181. So if they're able to cure whatever defect that does not comply with the rules, then yes, I would say that there is an opportunity to reapply or resubmit. But if the operation as proposed does not comply with the rules, the denial must be mandatory. There shouldn't be any leeway or discretion in that denial.
Thank you. I appreciate that response. And would there, is part of the issue sort of transparency, sort of, because understanding from the staff, and I'll ask them this question as well, but, I think there are instances where there are issues that emerge, and the staff is talking back and forth with the operator saying, hey, this isn't going to work, or we have this issue, or this thing is not, quite up to compliance, and we need you to make these changes. Is part of the issue transparency? Do we, is that some of the concern, is that there's not an understanding of those, that consideration that's going into the permit approvals?
And I'll let Natasha add on to this, but from my perspective, the issue is that if not the transparency, we understand that this is an ongoing process. We understand that there's communications back and forth. But if the end result is the operation not complying with the rules, denial must be mandatory. If we understand that this commission and this staff and the director are committed to protecting public health, welfare, environment, and wildlife resources, but say down the line we have a commission that doesn't have the same commitment, then I foresee an issue where an application may go forward even if it does not comply with the rules, because the rules allow for that discretion. So our concern is not with this commission or not the director or the staff. It's down the line, there is discretion put into allowing an operation to go forward even if it's not in compliance. So that is our main concern. I don't believe it's the transparency issue.
I would agree with that. Chris answered that perfectly.
Okay, Commissioner McGowan.
Thank you, Mr. Chair. I'm wondering if you all could briefly and succinctly remind me if the current mapping you feel is not adequate for the geological review, what in your mind would be? I know that you guys had a proposal, but if you could just really briefly remind everybody.
So first, we need an expanded definition of what a geologic hazard is. The statutory definition doesn't take into account adverse impacts to environment or wildlife. So you could have a situation where a geologic hazard is adverse to environment or wildlife, but it's not identified because the rules use the statutory definition. Second, while we require the operator to submit on-the-ground maps for the area, we also require a consultation with the Colorado Geologic Survey, which in our minds would include an on-the-ground analysis. And we understand that the COGCC does not have this geologic expertise, but the CGS, as you heard Dr. David No say, does have this expertise. And they also charge for this kind of review. So operators would have to take their geologic maps to the CGS for a consultation to be certified as accurate. In our minds, CGS, with their expertise, would conduct an on-the-ground review if needed. And I will say that almost every geologic hazard map that we've found, or a bulk of them, do have that limitation that says this must be used with an interdisciplinary approach of an on-the-ground review. It will not identify all specific geohazards. So there are geohazards that may fall through the cracks by just using these flyover maps.
Thank you. Thank you for that answer. Thank you for your presentation. I'm not seeing further questions from commissioners, so we will Zoom you away. Commissioners, just sort of a procedural check-in. When we set up today's hearing, we set 9 to 11:30 as our closing statements. We have 48 more minutes of direct closing statements and an unknown number of minutes of commissioner questions yet to go. And I know that some of us had some calendaring matters that precluded midday meeting. Not trying to put anybody on the spot, but do we want to press on now? Do we want to follow the script and take a break until 2, knowing that that may inhibit deliberations because we're going to spend the rest of the day on closings? I'm comfortable pressing on for another hour or so. What are folks' thoughts? Commissioner, I'm seeing some thumbs up. Commissioner Putnam and Commissioner Nanjapa both have raised their hands. Let's go with Commissioner Putnam first.
Sure. Thank you, Mr. Chair. I have a meeting that I can't get out of downtown, so I'm going to switch over to listening in the car and can participate in the car without camera and can do that till just about 1. I'll then be out of pocket from 1 to 2, but I do think moving forward makes sense, subject to what Commissioner Nanjapa may have in terms of conflicts.
Commissioner Nanjapa?
Thank you. No, I'm comfortable with moving forward. I was going to request maybe just a 5 to 10 minute break in the next half an hour, if that would be possible.
Yeah, absolutely. Why don't we take, say, 2 more panels and then take, say, a 5 to 10 minute break, and then let's plan on moving until, say, 12:50, and then that would accommodate Commissioner Putnam's meeting, and then so we'll take a break from 12:50 to 2 o'clock, if that looks good for everybody. Okay, Ms. Larson, next panel, I believe, is Colorado Rising. If we could bring Mr. Salazar to the floor.
Can you see me?
We can see you. Good afternoon, or good morning still.
Almost afternoon. Commissioners, Senate Bill 19-181 and other regulatory legislation was passed in 2019 because of the mess that we are in as a result of nearly unmitigated oil and gas drilling in the state of Colorado. For over a decade, the industry has gaslit prior commissions and the public. They have spread false and misleading information, and as a result, no permits were ever denied. Our air quality has gotten worse. The health of our community members around oil and gas development has been adversely affected. And we are in a climate crisis that even editorial boards such as the Grand Junction Sentinel are now, finally now, sounding the alarm about. Colorado oil and gas explosions are nationally highlighted. Oil and gas operations located hundreds of feet away from schools, homes, and other vulnerable areas have been featured on The Daily Show. And national political leaders have visited Colorado to underscore the pomposity of this industry and the past failed regulations of the state. Of course, the end result is that the legislature needed to create a sea change in oil and gas regulations. The legislature and legislators who testified before you were clear that public health, safety, welfare, environment, and wildlife resources now take priority over oil and gas development. And I appreciate how seriously you are taking your statutory mandate. Taken as a whole, the evidence substantially shows that at the very minimum, a 2,000-foot setback from the edge of the well pad from buildings, homes, and schools is absolutely necessary. The science, community complaints, community testimony, and your own records evidencing explosions, leaks, spills, and evacuations provide this commission all the proof and backing you need to enact such a rule. Of course, the oil and gas industry will have their paid professional witnesses attack the studies and evidence of scientists who are not paid by the industry. But the peer-reviewed studies have been growing for years, backed up by community members' experiences that oil and gas drilling is having a deleterious effect on people and the environment. We stand with the affiliated local government coalition that the language more than 500 feet and 604B needs to be removed and that there should be a flat 2,000-foot setback from the edge of the well pad. We also ask that you remove the ability of operators to ask surface owners to provide informed consent to waive setback requirements. It is a matter of basic Colorado law that waivers like informed consent are void if they violate public policy. Private parties cannot abrogate statutory requirements or conditions affecting public policy of the state. Informed consent would be an attempt to dilute, condition, or unduly limit the statutory mandates of Senate Bill 19-181. Along that vein, we ask that you remove language involving variances. Senate Bill 19-181 simply does not allow the Commission to establish a state floor of safety regulations, which it can then turn around and ignore by providing oil and gas operators the license to break the law. Such an act would be ultra vires, arbitrary and capricious, and contrary to law. In sum, the oil and gas industry simply does not have a right to drill. Coloradans and our environment, on the other hand, have a right to be protected. Thank you.
Myself unmuted. Thank you, Mr. Salazar, for your presentation and your closing statement and your participation with us. Do commissioners have questions? All right, seeing none, let's take one more. Oh, did we have one? Sorry.
No, I said thanks.
Oh, thank you. We will zoom away, Mr. Salazar, and bring Nate Bellinger with Earth Guardians and Our Children's Trust, and we will have his 3-minute closing presentation. Good morning, Mr. Bellinger. I hope that things are better in Oregon, air quality-wise.
Yes, thank you. They are. I'm happy to say we've received some much needed rain, although there's still a lot of cleanup ahead for the towns that were directly impacted, but thank you for checking in on that. So today, commissioners, I'd like to begin by first thanking the staff for all the hard work they put in to incorporate the input by the parties and the directives of the commissioners as they made numerous revisions to the 200 to 600 series rules. And in my time today, I'm going to focus on the 300 series rules, where we think additional work is needed to fulfill the Commission's obligation to evaluate and address the cumulative impacts of oil and gas development, and in particular, the industry's contributions to climate change and greenhouse gas emissions. With respect to evaluating cumulative impacts, while we appreciate the staff's efforts to include greenhouse gas emissions in the CITER database in Rule 303A5, we think 3 primary changes and clarifications are still needed to both that Rule 303A5BI and Rule 314E10A. First, while both rules state that an operator is required to quantify the, quote, incremental increase of the pollutants listed in the rules, there is no baseline provided by which to measure an incremental increase. So we think a better approach would be to require operators to submit a quantitative inventory of the total emissions of pollutants that are likely to result from the oil and gas operations. The second and third proposed changes we've outlined in our written statement are there to ensure that the greenhouse gas emissions inventory is comprehensive and estimates emissions over the entire course of the oil and gas development plan and from all phases of oil and gas operations. And we've provided some red line edits to these rules in our written filing. With regards to addressing cumulative impacts, we've also identified 3 issues there in our written filing, but in the interest of time, I think I'll probably just have time to address the first one. And that is Rule 304C19 alone, or in combination with any of the other rules in the 200 to 600 series, still do not appear to address the oil and gas industry's greenhouse gas emissions and contributions to the climate crisis in a manner that is consistent with meeting the state's greenhouse gas reduction targets and protecting public health and the environment. So while there are some efforts in the rules to reduce greenhouse gas emissions from the production of oil and gas resources that will inevitably continue in the coming decades, it's not clear that the rules will result in the necessary reduction in production of oil and gas resources in the coming decades. So we would greatly appreciate it if either during the commissioners' deliberations Or in the statement of basis and purpose, it could be explained how the rules will achieve a reduction in oil and gas production consistent with meeting the state's greenhouse gas reduction targets. So in conclusion, taking us back to day one of this hearing about 5 weeks ago, Chair Robbins' opening remarks referred to Bernard Looney, the CEO of BP, who said that the trend for clean, reliable energy is here and it's unstoppable. So the commission, we think, should be planning for this unstoppable trend in energy production away from fossil fuels and towards renewable energy sources. Thank you.
Thank you, Mr. Bellinger. I appreciate your and your clients' contributions to the work we're doing, and appreciate your closing statement as well as your written closing statement, which we read. Do we have questions? Commissioner Putnam.
Thank you, Mr. Chair, and thank you, Mr. Bellinger. I had a couple of questions about your recommendations on the CIDR data. The first is just to help me understand how a total life cycle emissions calculation will work when a lot of our, for example, ozone attainment are based on annual or seasonal or daily amounts, and even our greenhouse gas objectives are based on a kind of annual basis to achieve certain milestones in years like 2025, 2030, and 2050. So curious how changing that to a total life cycle emission will help actually be useful either for this commission or for CDPHE.
I think you could do a total life cycle emissions estimate on an annual basis. So that could make that data more perhaps user-friendly for the purposes that you've identified. So I guess what we're trying to address there is, there are emissions from, the extraction, the transportation, the combustion of all those oil and gas resources. And we think all of those emissions should be estimated. And I do think that there would be a way to do that on an annual basis, as well as a, say, basis over the course of an entire well. I think those could be separate calculations.
So just to better understand then, when you're saying life cycle emissions, you're looking for the kind of downstream emissions associated with midstream transportation, refining, distribution, and the ultimate combustion of the gas or oil products to be part of that calculation?
That's right. And I think it's important to include those emissions in the estimate because it's all of those emissions that are contributing to the eventual release of greenhouse gas emissions and climate change, which is causing significant impacts on public health and the environment. So I think it's within the Commission's legal authority and responsibility to be considering all of those emissions.
Thank you. That helps clarify, I think, some of the suggestions that you had. I had one other, which is to understand you were looking for a change from incremental increase, which I think is in staff's recommendation, to total emissions, and curious what that means and how you would account for reductions in emissions that might be associated with plugging vertical wells or some of the other places where there could be a reduction in emissions, as well as increases in emissions, and where that would sit in a appropriate form of accounting under your views.
Sure. In our proposed red line changes to Rule 314E10A, we suggested that any reduction in emissions from plugging in abandoned wells be separately itemized. I think it's important to know both whatever emissions will result from additional permitted activities, irrespective of any reductions. And I think the hard thing, maybe it could be explained if the commission staff has something in mind to kind of further illustrate what the incremental increase is, I don't understand. I'm not clear what the increase is being compared to. So there's no baseline emissions by which to measure that increase. You know, if somebody said to me, I want to know the increase in your child's height over the next year, I would need to know her current height. And so we don't know, it's not clear what that current level is. So that's why that incremental increase language seems confusing to us.
And then maybe one more additional question, just going back to the life cycle emissions question and kind of going to your question of baselines. How do we address what alternative sources of supply would look like in life cycle emissions if this commission can't affect demand for those products? If you know, a product isn't coming from this state, it could come from another state, or internationally could come from oil sands or Permian. It could be shipped from overseas. How does that kind of fit into understanding the kind of total or net life cycle emissions associated with a particular proposal in front of the commission?
So I think if I understand the question, you're trying to kind of get at, you know, what happens if Colorado reduces its oil and gas development and then just increases its import of oil and gas resources from other states. And I think, you know, one thing to note there is that there's been some research on this idea of perfect substitution or leakage, under which it's assumed that, you know, limiting the production of fossil fuels in one place will never actually limit the consumption or affect emissions, because other sources will simply fill in that missing production. And I don't think that the evidence supports that theory. And I think there's a lot of, you know, Colorado has set aggressive greenhouse gas reduction targets. A lot of other states have as well. And so I think there's a trend towards reducing fossil fuels and moving towards alternative fuel sources that is true in Colorado and elsewhere. And I don't necessarily think that any reduction in production in Colorado will necessarily just be filled in by imported fossil fuels.
And thank you, Mr. Bellinger. And I think that may or may not be true in the long term. And you're certainly right that the state is looking at a number of those measures as part of our greenhouse gas planning, and believes that we do need to displace that and move to different sources of fuel. But in the short to medium term, if we stopped adding production in Colorado, is that going to lead to less driving, fueling of homes for natural gas? Is it reasonable to assume that it won't be substituted from another state with a higher greenhouse gas intensity like the Permian? And are we really achieving a net benefit?
I think the answer is yes. And I think, you know, partly for the reason I just explained, I think the trends are towards renewable energy sources. And I also think, you know, this is what we've proposed in some of our other filings is a transition. You know, we're not talking about shutting down all oil and gas resources in, you know, 1 year or 2 years. It's, you know, a multi-decade transition. So I think that that's what we're really looking for the commission to start incorporating into its rulemaking. And I think that that transition can be phased in a way that doesn't result in an increase in fossil fuels from other states.
Thank you, Mr. Bellinger.
Thank you. Thank you for those questions and those answers. I'm not seeing other commissioners with questions at this point. Let's take how about a 7-minute break and come back at 12:10 to 12:50. And then we will break from 12:50 to 2 o'clock. So that's our next steps.
Chair Robbins, I think you're on mute.
Sure enough, I'm on mute. Hold on just a sec. Let's wait for Commissioner Nanjapa to get back onto the Zoom meeting. Okay, we are ready to go. Ms. Gutierrez, you have the floor for, I believe, 3 minutes.
Let me go ahead and share my screen quickly. Okay. Are you able to see my screen?
We can.
Great. Okay, good afternoon. We've made it to the afternoon. My name is Ana Gutierrez with Hogan Levels on behalf of Kinder Morgan CO2 Company. You'll recall that our filings and testimony have focused on federal interaction. Our proposals did not ask for a carve-out, but rather we proposed processes that would allow for coordination between the agencies to avoid conflict. In response to staff's September rules, we are disappointed our revisions were not incorporated. It is important to understand that this is not a small issue impacting only a few operators. In Colorado alone, BLM administers 8.4 million acres of surface estate. This number doesn't account for other federal land management agencies. This is an important issue impacting a significant portion of the state, and it deserves commensurate attention. During the testimony I provided on August 26th, AAG Minor indicated that his team would like to hear from BLM rather than from industry. We wholeheartedly agree, as we understand the importance of BLM's perspective. In response to that request, the BLM state director sent a letter to Director Murphy stating, quote, "The BLM has expressed and will continue to express the importance for the COGCC's new rules to recognize the role of federal authority and decision-making for activities on federal lands. The letter also reminds the Commission that BLM must fulfill its congressional mandate to balance multiple uses." No substantive revisions were made in the September rules to address BLM's comments. Since providing testimony in August, we have tried to meet with staff together with BLM and the solicitor of the Department of the Interior, the highest ranking attorney for BLM's parent agency. Unfortunately, those meetings were both canceled last minute due to staff schedules, and we understand there's a lot going on, but I'm confident that if we have the opportunity to meet, we would be able to reach reasonable resolution. Our new proposals are shown on the screen, and they're also in our 4-pager, so I'm not gonna linger on this text or read it to you. While we would prefer our more robust language proposed on August 26th, in the spirit of cooperation, what we've proposed here is language to model staff's new approach to coordination with local governments. There is no reason the federal government should not be given the same due respect. We recognize that coordination between the federal agencies and the Commission is the expectation at this point in time. We're asking only that this expectation be memorialized in a rule. I would note that addressing federal jurisdiction is not foreign territory for this Commission, as the Commission addressed the issue directly in the recent flowline rulemaking in at least one instance. I would also note that parties and the commissioners, even just this morning, cited to federal agencies' processes as quality analyses that the Commission should model, and in particular with respect to reasonably foreseeable impacts. It seems only prudent that we recognize the federal government's expertise in the rule. We applaud staff for the extensive work they have put in, and we appreciate the complex questions involving federal lands. Further revisions are required, however, to ensure that the Commission's new program complements BLM's longstanding program. Thank you. I'm happy to take questions.
Thank you. If you could halt the screen share.
Yep.
We have questions from commissioners. Commissioner McGowan.
Maybe no question, but maybe this is something we can ask staff about, this compromise language. I guess the comment that I would add is that I didn't see in the letter from BLM that they thought that we were doing anything that was in conflict, just that they stressed the importance of recognizing the role that they have and that we cooperate with them, which I feel like I hear staff saying. So I just want to clarify that as well.
Director Murphy.
I'm happy to take a look at the language Ms. Gutierrez has provided, and we have been working with BLM. I did want to note that I thought that the meetings that we rescheduled for BLM were focused on the 1200 series and wildlife, and that's why I felt that it was imperative to reschedule them. I didn't realize we were going to be talking about 200 through 600, so I'll take a look at the language, and we can I guess report back as you see fit, commissioners, if you think it's appropriate to consider.
Okay. Thank you, Director Murphy. Other questions from commissioners? Okay, seeing none, we will zoom Ms. Gutierrez away and request the Western and Rural Local Government Coalition to show up for a 9-minute presentation. Oh, wait, Ms. Larson, I think you had a edit due to a scheduling issue.
Yes, thank you, Mr. Chair. We were wondering if we could take Western Resort Advocates after the Western and Rural Local Government Coalition presents.
Yeah, that's fine. They were later on the list, but to accommodate that schedule, that's fine. So let's take Western and Rural Local Government Coalition now. And the Western Resource Advocates, you're on deck.
Chairman Robbins, just some preliminaries before our time starts. We have two presenters, Mr. Lepore and Mr. Nguyen, and my associate Hayden Weaver will be sharing screen on a map slide during Mr. Nguyen's closing remarks. Do we have everyone present? If so, we can get started.
I don't see Mr. Weaver. Now I see Mr. Weaver. Mr. Weaver, do you want to share your screen whenever you like?
Correct. He'll be doing that during Mr. Nguyen's remarks. Okay, I think we're ready to go, Matt.
Just before we get started, I'm having a little bit of internet connectivity. So if you have any issues seeing or hearing me, please flag that for me. I just have a really tough connection here on the Wi-Fi. Anyway, let's go.
Got it. Thanks.
Good afternoon, commissioners. Nice to see you all again. Thank you all so much for the attention and effort that you have put into this monumental rulemaking. I also want to give a special shout out to Director Murphy and her staff, who over the last several days have done an amazing job. I'm thinking especially of 604 and the effort that has gone into that, I think, to bring us to really a razor's edge line of completing a nearly impossible task. So terrific work there. I want to start with thanking you all for your consideration with respect to Rule 201C. We had asked that the last sentence of that be stricken, and that is the current recommendation in the current rules. We hope you will abide by that, as we think that it sets the right standard for the balance between local and state authority under Senate Bill 181. Turning to 604, Part B, we agree that a hard setback of 2,000 feet is not necessary to protect public health, safety, welfare, and the environment, and we oppose any efforts to turn that into a hard setback. We understand 604B written to be a siting requirement that has clear and attainable pathways to approval of oil and gas locations less than 2,000 feet from a residential building unit or a high occupancy building unit. If implemented in that way, we believe, again, that that would strike the appropriate balance between the state's authority and the local government authority to regulate oil and gas under their respective provisions and authorities. From Western rural and local governments perspectives, there are a couple pieces of 604B that are vitally important. One of those is the reference to geology, topography, and technology as a consideration for siting. Those are real world effects in the Piceance Basin and other rural local government jurisdictions. We appreciate that language being included and urge you to keep it. We similarly believe that your consideration of the relevant local government siting decision should be at the very top of your list of things that you consider when deciding whether or not to approve a location under 604B. Turning to more general provisions of 604B, about which you have heard a great deal this morning. It is important to us that your consideration under 604B take place under Rule 510 hearing, as the current draft states, and not pursuant to a 502 variance. 502 variance is a two-step process, 2 bites at the apple, potentially different legal standards applied. We support the current language that would have that proceed under 510. We have grave concerns about substantially equivalent language. You have heard about that from others. My comments would essentially echo those of former Director Neslin, so I will stop in the interest of time to say that we think it is unnecessary to introduce a new ambiguous standard into this very, very important rule. We urge you to adopt, protect, and minimize as the statutory, one and only statutory standard. Thank you, and I'll turn it over to Kirby.
Thanks, Matt. Now I'm going to focus on a few critical changes that you can and should make for the benefit of all relevant local governments who are, by law, provided co-equal siting authority that is largely distinct from COGC authority and thus must be accounted for, lest this commission merely give lip service to what co-equal means. We believe co-equal means the commission and commission rules start with a strong presumption that RLGs get it right when they approve a site that they know to be protective and that they accounted for via alternate siting options. WLG thanks you and the staff for building a formal consultation process with relevant local governments and operators into Rule 301F. These provisions ensure COGC will, if invited, participate in the RLG pre-application process to discuss potential alternative locations for analysis and other key matters that will aid the RLG to ensure its siting decision comports as fully as possible with commission rules and preferences, and thus drastically minimize state-local conflict. The updated rule also ensures the commission acts as a referral agency to the local government permit review process. We urge you to keep this language exactly as is to avoid unintended and harmful consequences. Concerning nuisance impacts under rules 4023 to 27 and regarding broad director discretion to allow a less stringent local standard be applied, we propose and urge you to incorporate a more firm criteria such as, and I quote, the director will apply the less stringent local standard so long as it is protective, end quote. To do otherwise would be a case where the commission could be merely giving lip service to the legal standard that the state and RLG have co-equal siting authority, and thus would ensure there will be significant state-local conflicts that are avoidable. There seems to be no objectively reasonable basis for the director exercising her discretion to not apply the less stringent local standard if it is in fact protective. And we advise and suggest clever crafting of rules that would dodge around the simplest question, is it protective, is not appropriate in our view. And what I'm speaking of affects rules 423B3C and 424D3C. A third item I'd like to talk about is to thank the commission and staff for revising rules 507A1, 507B, and 507C to not automatically grant proximate local governments affected person status for the purpose of contested hearings on siting decision. This important decision, in our view, avoids unnecessary conflict between RLGs and PLGs. We are sure you will hear alarmist calls, or maybe already have today, from some of the more perpetually proximate local governments who have little actual oil and gas activity and experience to draw upon. But we urge you again to respect RLG's co-equal siting authority and local permitting process by fending off calls to add back in PLGs with automatic status. They would have just a very limited showing required to gain affected person status, and we don't see that as onerous. And finally, returning your focus to Rule 604B, WRLG strongly endorses the 4 specific categorical 2,000-foot setback exceptions included in your recent drafts. We do offer and emphasize one important clarification, and that's for 604B4, large B, little I, identifies geology, technology, and topography as factors the commission will consider. This is critically important to WLG members and every local government with jurisdictions where these factors make it impossible for operators to reach minerals from more than hundreds or at most a couple thousand feet away on average. Those factors can make siting decisions extremely challenging in our jurisdictions and across much of the area of the state outside the DJ Basin. I also would add, and we can talk about it during Q&A, but Mr. Freeman's setback analysis is at best highly erroneous. I believe Mr. Hayden's going to show a slide, and perhaps biased. We know the setbacks he used, that Mr. Freeman used, fairly, we know them well, and he abused them quite a bit in our view. Our more rigorous and quality checked analysis shows about 41% of wells are triggered at a 2,000-foot setback. Mr. Freeman also presented a skewed analysis in our view of the commission's directional well database to say operators in our area regularly reach 3,000 feet laterally. I checked those numbers myself. It's a low percentage of wells that reach 2,000. I think it's in this, I don't have it in front of me now, but I think, and you guys can check it easily because it's your database, over 70% of wells are less than 2,000 feet. That number might actually be at 1,500. It goes exponentially from 1,000 foot that it becomes more and more rare. Again, we can discuss that later. We mapped our setbacks based on true actual home locations and not just a national address database. The one Mr. Freeman used is probably better for mass marketing mailers than Senate Bill 181 policy development, is my view. Now Mr. Weaver is sharing a GIS map of a portion of Garfield County, hopefully, in a prolific natural gas area near Rifle in the town of Silt. As you can see, the effect of a hard 2,000-foot setback, and I guess you're not seeing that map yet, but in that area creates miles-wide swaths of mineral resources which would be sterilized without multiple readily available and approvable exceptions, including those due to geology, technology, and topography. And as a prelude to your scheduled consideration of large riparian setbacks in the 1200 series, if those are combined with 2,000-foot setbacks from all building units, large portions of the rich mineral resources of the Piceance Basin are sterilized and made wholly unavailable to even the most stringently regulated and responsible production activities. We expect the same to be true and should be verified before you do such setbacks in other regions of the state, rather than just wonder. Simply put, a statewide setback of 2,000 feet from building units will pit this commission against all local governments that base their land use decisions on science and available technology, and who also need the economic benefit that oil and gas development brings to their communities. But that conflict can be avoided by you now. Please retain and expand available exceptions to the greater setback distances contained in staff's latest drafts. Only by doing so will these rules reflect a balance of authority to regulate oil and gas based on Senate Bill 181. Thank you very much, and we appreciate your hard work and attention to all these matters in our remarks. We're happy to take questions.
Thank you, Mr. Nguyen and Mr. Lepore, Mr. Jacobs. Do commissioners have questions for the panel? Commissioner Messner.
Thank you, Mr. Chair. A couple of questions just to clarify. Well, and then just to ask a couple of questions. So one of the stakeholder groups is suggesting the utilization of language in the 604 rule that there needs to be a showing by operators that accessing the targeted minerals would be technically unfeasible. And then also that they made a reasonable attempt to obtain waivers. Do you think that's, I mean, I think I've heard this group indicate that there's going to be some challenges around reasonably obtaining waivers. And I've heard this group say that there's some challenges around technical feasibility of being able to access minerals 2,000 feet. So would you agree with these suggestions?
Matt?
Thank you, Commissioner Messner. I appreciate the question. Technical infeasibility first. I always come back to the baseline of understanding that a mineral owner, when they acquire the minerals, acquires the right to access the surface above those minerals. So asking an operator to go find a different location so it can be farther away entails those considerations. I don't know whether you consider those technical feasibility or not, but they are very real considerations of acquiring a new surface location and potentially acquiring the right to penetrate the minerals in between their surface location and their own minerals. I think if you factor that in and you factor in the other technical considerations that we have emphasized, then yes, operators will be looking hard at trying to locate as far away from residential building units as they can and still feasibly and practically access their minerals. So I would absolutely throw it into the mix of things that we would expect you to evaluate when someone comes to you and says, we're looking to be closer than 2,000 feet. As far as obtaining consent, informed consent, to me, that one's a little bit more of an either or situation, the way that it's currently written in the rules. I would expect in some circumstances, operators would approach those nearby residential building unit owners or high occupancy building unit owners and perhaps attempt to get their consent. In some cases, we've talked about, it might be the mineral owner themselves. But I think that should be their option as it is written in the rules. They can use that approach or they can use the 604B4 approach.
Thank you.
Okay, thank you for that. Sorry.
No, did you have follow-up, Commissioner Messner?
I have a different question unless people have follow-up on this one.
I'm not seeing anyone jump to the fore. Keep going.
Okay. The only other question I have is And I'm just trying to understand, because I think Mr. Nguyen indicated that, the utilization of language in the 400 series of is it protective, would enable people to be able to dodge that language. But yet I'm also hearing you suggest in the 600 series that the word protective minimize should be utilized in lieu of substantially equivalent. So help me understand why it's okay to use in one, but not in the other.
I'll be happy to. Either I misstated or you misheard, but I'd be happy to clarify. What I was advising was, if the commission endeavors to cleverly craft the rules, so the commission is dodging around the simplest question of, is it protective or not, was the concern. I don't think the operators are doing that. What we're asking you to do is ask, is it protective? And if it's protective, then it's on its path to being considered for approval, not something other than that. And so if it's protective.
So you're okay with the language protective in both the 400 series and encourage it to see it in the 604.
If the substantially equivalent, I'm not okay with substantially equivalent, not at all. That's
not what I said. I said the word protect.
And I know where it came from. I think you brought that up.
Mr. Nguyen,
Yeah,
can you repeat? You were breaking up there.
I appreciate your letting me know. Yeah, we think that the commission in the rules in the 400 series should be asking, when they're looking at a local government siting, did the local government come up with something that's protective? And if so, then those standards, those lower standards should be able to be applied, the less stringent standard.
If I may add to that briefly, that was in connection with the director's discretion may apply the less protective standard or the local standard. We just don't understand what discretion on the part of the director is to be exercised if in fact the local standard is protective. Why would the director exercise her discretion to not apply the local standard if in fact it is protective? There's just no reasonable basis for that. And I think that's what Mr. Nguyen was speaking to that drew your question, Commissioner.
Thank you, Mr. Jacobs.
Thank you.
Commissioner Nanjapa.
Thank you, Mr. Chair. I had a question, and I know I had made a request about looking at that map at a closer scale. From what I could tell from the map that you presented, it was about 14 miles in total that was viewable there. Would it be possible to zoom in on that? I don't know if any of you are able to do that at the moment, or if that's something that you could submit for the record, but that would be really helpful for me to just get a better understanding, since you have the more accurate data that you're looking at. Would that be possible?
I would ask Mr. Weaver to pull that map up, and let's do that. And I also want to look at that table, because more germane to your question, you wanted to know about 500,000, 1,500. I guess I would suggest we start with the table and then zoom in on the map, if that's okay.
Okay, and thank you, Mr. Nguyen. I think a follow-up question that I also had was which I think I mentioned in previous portions of our testimony, of our hearings, was how many of those locations that you noted would be flagged, how many of them could not be located further out, and for what reasons?
Okay, so are you all looking? I guess we're looking at the map. You're looking at the map now?
Table.
We're looking at the table.
All right. So I'm sorry, and I told Mr. Weaver to show the table. I cannot see the table. Let me pull.
The table's up, Kirby.
So on that table, it shows at 500. What? I'm trying here.
We're looking at the table.
Right.
All right. I can't see the table. Let me see here. I'm going to turn off my video in case that might help. Anyway, on the table, I would ask Mr. Jacobs to read the number of wells impacted by 500, 1,000, 1,500, and 2,000, because I cannot see the table.
That's fine. It's the table that was flashed at the beginning of screen share in your testimony. 500-foot setback would have flagged 586 wells. 1,000-foot setback would have flagged 2,358 wells. 1,500-foot setback would have flagged 3,687 wells. And 2,000-foot setback would have flagged 4,560 wells.
Thank you, Mr. Jacobs.
Certainly.
So, Mr. Freeman presented something on the order of 1,900 wells at that 2,000-foot setback. He used this national database, which is known to be crummy, for actually identifying there's actually a home located there or not. So I know our data to be significantly better than the data that you heard from another party. So of these 4,500 wells for the 2,000-foot setback, that's on the order of 40% of all existing wells in Garfield County. And so if we go look at the map, please.
This is the Rifle Silt area map at 2,000-foot setback, Kirby.
All right, I can see it now. So those red grids, those are 1 mile grids. They're not perfect, but they're pretty close. That's the township and range section lines. So there south of Silt, you can see you've got an area that's on the order of, it's 4 to 5 miles wide by 4 to 5 miles north and south. You see the similar sort of things in some of these areas of Rifle. So each one of those circles is a 2,000-foot setback, which means that each one of those circles has a circumference or diameter of 4,000 feet. That's practically a mile. So when the question is, how could they resite those wells? Put yourself in the middle of that area where all the green dots are. Those aren't existing wells. Those are well pads with 10 to 20 wells, 1 well, 5 wells, 20 wells, 20 wells. But anyway, those are well pads. And so there south of Silt, I would ask anyone looking at this commission, you go to the middle of that area where that hand symbol is there. How can you go, if you have a 2,000-foot setback, where are you going to go when you are limited to 2,000? And even if we granted Mr. Freeman his incorrect analysis that 3,000 feet is easy to reach, which is not with our geology, and I know it and your data shows, how are you going to get there? That sterilizes minerals. If somebody wants to go in there and fill in some of these areas that don't already have well pads, they're out of business. I hope that somewhat answers your question. I don't see a path when you can only reach about 2,000 feet or so where you're going to go to reach those minerals, which is why the local governments need the ability to come up with protective decisions and present those to the commission for consideration and have that be considered as a strong reason to consider if the local government got it right.
And more specifically, I might add, Commissioner Nanjapa, we've done the best we can with GIS expertise from Garfield County in preparing this map for today's closing remarks. We've not been able to engage in a well by well or pad by pad analysis to respond to your question about alternate locations, but I think Mr. Nguyen has done a good job of responding, especially within the large merged blue areas where the 2,000-foot setback precludes miles wide by miles long areas from consideration for development, unless there are readily available or reasonably available exceptions to that setback. I hope that answers your question.
Commissioner Nanjapa, did you have follow-up?
Thank you, Mr. Chair, and thank you both for those explanations. I think, part of my question, and as I mentioned during Mr. Freeman's presentation as well, is that, with GIS, the view scale matters, the level at which you're viewing and visualizing the data, that matters. So, for example, the well pad or the wells within 2,000 buffer, those circles that you have there, potentially they're with those 1 mile squares, they're in the neighborhood of, a 15th of a mile across. And so I want to get in closer to get a better sense of, the residential units that you're buffering around and what that looks like. Because when we use these kinds of methodologies with mapping wildlife in order to provide enough uncertainty that you don't know where the exact location of the wildlife is, because you don't, for some sensitive reason. But when you get in close, you can see, where those point locations are, where those distances are, and that matters. So that would really help me to get a better understanding of what you're suggesting here. But the other piece, as I mentioned before, that I think would be really helpful is, it's one thing to say there were so many that were already within this buffer that we're discussing, but what I want to understand is how many and what are the reasons that they could not have been located out further. Is it a technology? Is it a topography, geology issue? Is it something else? Is it the surface ownership? I understand that there are those hurdles, but getting a better sense of what that looks like would be really helpful.
I'm going to take a stab at that. So it's the geology for sure. What I was looking at was the geology, because what I was thinking about and I looked at was the database as showed, and I confirmed with 4 operators. Yeah, we get up to 2,000 feet, and that's our max a lot of times, because our downhole depth below surface where the minerals are is shallow enough, and to build a directional well, you just can't. You have to build those. I talked about the last time we gave testimony. You have to have these sort of softish curves to make that S curve and hit these minerals in a vertical aspect rather than a more horizontal one. So they have to correct to get back more vertical by the time they hit the minerals. And so that's why they have this 2,000 footish, and actually a huge proportion, they can't get more than 1,500 feet. So it's not like they can always go to 2,000 either. There's a bunch that they can't. And so the geology is a big one. We have a ton of topography. I'm not showing you a topographic map. I kind of did the last time we gave testimony. But in these areas where most of the homes are, is the geology is controlling and unfixable. And there is topography as well. There's some other, the surface owner issue. I mean, that's before you even think about if the surface owner might give them permission to put a pad there. Even before you get there as an option, you're closed off by the geology almost fully in these areas. And that's not a negotiation thing. It's just the geology is what it is. So it's technology combined with the geology. In large part is what I think we've mapped here. And I believe we have a good representation of it. 40% of all wells would be hung up by this. Can some of those 40% be reached? Sure. Where you don't have these giant blobs that are, because again, each of those circles is 4,000 feet across. So if you join 4 of those just sort of side by side to sort of make a square, that's 8,000 feet by 8,000 feet. If you can only reach 2,000 feet, you're stranding and sterilizing minerals.
Mr. Nguyen, just one follow-up question, and just to be clear, does your map take into account homes that may have been placed near wells? I mean, like, did you kind of do the reverse analysis, or?
No, and we do, and in my, I guess I'm pushing 10 years now doing what I do. I see every home application that endeavors to push close to well pads. I'm like a referral agency to my own county as a liaison, and I look at those, and we look and we make sure that the operator understands where somebody wants to put a home, and that the state gets, you all get a letter that would indicate that the operator approved it being inside whatever the setback is, that sort of thing. So there's not a lot of that, but there's some. But what I had to take was, in the time allotted for this hearing and preparing, was actual homes and doing buffers around homes that exist today. And I wasn't able to take the time to try to ferret out, well, which of these homes came in after the well pad. There's just no way we could do that analysis, but not in the time we're talking about.
Okay.
But I also don't think it's a majority part of it.
Okay. Thank you. Are there further questions for this panel? Commissioner Messner.
Thank you, Mr. Chair. And thank you, Commissioner Nanjapa, for asking those questions. Those are good questions and ones that I was thinking about as well. I'm going to potentially embarrass myself here, but I think I did math. And at 4,560 wells, existing wells that would potentially be impacted by a 2,000-foot setback, understanding that, you know, the analysis here is based on a hard setback, and that's actually not what we're discussing. But nonetheless, that means about 61% of the wells, the existing wells, would be outside of that 2,000-foot buffer, which leaves about 39–40% of the wells that would have been impacted by the potential hard 2,000-foot setback, which is actually very similar to the data that Mr. Freeman indicated as far as the initial numbers. I think Mr. Freeman went a little further in analyzing how many wells inside, or how many houses inside of those 2,000-foot setbacks, and the percentages of those. So he indicated, you know, and I can't remember exactly what they were now, but some percentage of situations had 4 or less homes, and some percentage of situations, I think 70% of those, of that 40%, had 9 or less homes. You know, and so actually, I think your data is somewhat similar, it appears to me. But I do think, and I understand that this GIS stuff is difficult and time consuming. But I would concur. I think Commissioner Najaba asked for as much detail as you would be able to provide, understanding that it is a short time period. But I also would be interested in more specific detail because scale does matter. And so, you know, if you have the ability to do that, great. Certainly would help us in our deliberations. If you don't, I understand that as well. So, thank you.
Yeah, I appreciate that. If I might touch on something, and those are great comments. I appreciate that and the question. What we're talking about here is the state, y'all, the commission. You have no idea what this mapping looks like on a statewide level. Thankfully, we have excellent GIS resources locally for one of our 15 counties. You're hearing from a lot of operators and people saying this 2,000 foot creates a problem. So the issue is everyone has pretty much agreed except for a few parties, including the commission. Y'all have said, you know, we're looking at soft setbacks because we know, and the question was asked and answered. Mr. Sura said, yes, you can have a protective site within 2,000 feet. So that begs the question, why would you set a hard setback or do anything that just completely disregards our relevant local government's absolute ability to do the things I'm talking about today on a daily basis on siting and alternative location analysis? The rules should make it easy for the local government to use that granular data on a daily basis to make siting decisions, and y'all's rules should look at that and presume the local government got it right. Look to see if there's flaws, but the rules should be drafted presuming we're going to get it right because we have better data every day on land use. Every day we do.
And if I might add just a point of clarification in your request, Commissioner Messner, and also that of Commissioner Nanjapa, if we were to be able to get you fairly quickly some greater resolution, zoom in, if you will, to look at building units within these 2,000 foot blue circles that are actually 4,000 feet in diameter, as Kirby explained. I'm encouraged because we want the ability to have readily or reasonably available exceptions to a 2,000 foot setback within which to look more closely and make protective siting decisions. That's what Kirby and Matt are advocating for, and I am as well. So, but logistically, when, you know, depending on what we can do and how quickly we can do it, how might that be submitted to you for your consideration? And maybe that's a question for Mr. Davenport, Chairman Robbins. I just don't know the answer to that.
I think that Commission has the ability to request information at any point during its rulemaking. Commissioner or AAG Davenport will show up and correct me if I'm wrong.
Okay.
And with that being the case, if you have an ability to get the data that's being requested, email it to Ms. Larson and she'll get it to the commissioners as well as to parties.
We would welcome that opportunity if in fact we can do anything in you know, a short period of time. We will, again, because we want the ability for reasonably available exceptions to a 2,000-foot setback to be utilized by this commission and also by local government, obviously. That's what our position on 604B is all about.
AAG Davenport.
Mr. Chair, you're correct. You can ask for that information. That's fine.
Great. Commissioner Nanjapa.
Hi.
Hold on just a second, Kirby.
Yeah, thank you, Mr. Chair, and thank you both. I just wanted to, I appreciate that you're willing to provide that map. And I believe it should be a fairly simple request. I did a lot of GIS 20 years ago, and if you have the point data set for the residences, it's a matter of, you know, putting in a buffer and just zooming in to the scale. And what I would like to see is about a 5-mile scale. You can show me show us, you know, several locations, you know, wherever you think is most pertinent, but I think that would be really useful. The other piece that I think is really important is the question that Chairman Robbins asked is, you know, how many of those homes came in after the fact? So could you give us an idea of the, you know, the year that the well was put in versus the year of the home? Again, I would imagine that in a database, you would have that information readily available through a query. So I would really like to understand that as we think about these things and to address the question that, or the issues that you just raised, Mr. Jacobs, you know, in making these decisions and understanding kind of what's going on, and just reminding everybody listening that whatever setbacks we set, don't change land use decisions that may occur after the fact with an approved location where a house could be put in closer than that, whatever the setback is that we determine. So that does also matter, and there's a sort of a different aspect of you know, what goes into those homes that come in around a location that has previously been approved. So understanding all of those pieces would be really helpful.
Okay. I appreciate that. Again, I'm just going to say, so let's say we're able to pull this off for Garfield County. My GIS analyst, who has all the stuff and knows what she's doing as an expert, she's elk-hunting, I think, till September 30th. She's out in the mountains somewhere. I can't reach her today if I want to.
Sorry.
So I'm not sure what we can provide, but more importantly, what does this say about Rio Blanco County, Moffat County, Logan County, any other county across the state, Los Animas? It doesn't say a thing. Our point is there are homes spread all over rural Colorado that get hung up on a 2,000-foot setback. That's the reason why local governments need to be respected with their local authority to presume they're going to get it right, and you should check it. I don't think you're going to get near enough data to say, oh, we got a perfect answer here. This is the setback because Kirby gave us some stuff for Garfield County. I am dubious that you're going to be making an especially informed decision no matter what we give you for one county. That's my concern.
So I appreciate that perspective. Commissioner Nanjapa, did you have a follow-up?
Thank you, Mr. Chair. No, and thank you, Mr. Nguyen. No, I agree. And in fact, because you are representing the Western regional local governments, I would very much appreciate maps from some of the other counties as well, so that we can gain a better understanding. I think the staff has drafted, and we are going to deliberate on, you know, these other pieces of what comes in, or whether or how the off ramps can come into play. But kind of getting a better sense of that landscape is what will help inform our decisions. So I hope that makes sense.
I understand. I'm sorry, I did query our other counties. I didn't find any that actually had, and our data isn't perfect, but we had a GIS person who's now actually retired, but he went through and he ground truthed a lot of these home locations, most of them, with aerial photography. So he could see the house. He made sure that point was right where the house was, as he said, within 50, 60 feet. And when I zoomed in, I kind of saw that. I mean, this is not published perfect data, but it's one county's attempt to understand where homes are for emergency reasons, whatever. And it's, you know, it's the best we have. I don't know of any other county that has that. And I asked. And so it's just a challenge. And it just goes back to write the rules that allow local government to do its job with the best land use data it will always have, that will always be better than the data the commission will have in hand as that first cut on siting, and expect to try to see that they did it right and prove them wrong if they get it wrong.
And Mr. Nguyen, to try to nip this, I think I heard both you and Mr. Lepore actually suggest that the razor's edge that we've created does just that. And while we may not be, and so that on an as applied basis, we now have proffered to the commission from staff this 301F early on involvement, as well as while there might be a 2,000-foot siting requirement, there are off-ramps for surface owners and for geology and topography and technology. And I think I heard you guys say that while you probably would rather not see it, if it's there, those things are helpful on an as-applied process as we start to regulate under an arena such as the one that is being proffered.
This is true. I think it's the difference between trying to make the rules work over the next couple of years and seeing everyone work together, or just re-energizing the so-called oil and gas wars, which would happen if there was a hard 2,000-foot setback. Mineral owners, I mean, you can't even talk about mineral owners. What about those people that own those minerals and they have those stranded miles-wide swaths of minerals? There's no way they're going to sit still and go, well, thanks for taking away our wealth and my child's education, college education. I mean, these issues are local government issues. These are land use impact issues.
Yep.
And they're mineral rights owners issues too.
Thank you for that, Mr. Nguyen. Are there any further questions for this panel? Okay, seeing none, we're going to sweep you guys away, and we need to bring
order. Mr.
Yeah.
Chairman, just to the extent we have any time left, I believe we were going to cede that to Weld County.
Okay, I will make sure that Ms. Larson cedes any time you may have had left to Weld County.
Thank you very much.
We need to get one more panel on to accommodate a witness who would not be available this afternoon. So let's bring the WRA panel on board. And then that'll be a 3-minute presentation, I believe. Looking for Ms. Walker.
Hi, thanks for accommodating me. I really appreciate it.
Yes.
I'm going to share my screen. Thank you, thank you. Okay, so as the staff acknowledges, the most recent versions of 303 and 314 are intended to give the commission the information it needs to both evaluate and address cumulative impacts. This is an independent duty, but also key to protecting, avoiding, and minimizing adverse impacts and giving the public the information it needs to participate in permitting in a meaningful way. With this in mind, we make 3 recommendations. First, that in the context of ODGPs, operators are required to estimate future emissions of air pollutants and hazardous air pollutants for pre-production, but only the first year of production. And with caps, it's pre-production plus the duration of the cap plus 5 years. We suggest that these estimates are not adequate to inform the commission or the public of the cumulative impacts of the project, including on climate. So to ensure that the commission and the public understand how air emissions, including methane, will impact Coloradans and their environment, we recommend that operators be required to estimate annual production emissions over 15 years or the life of the project, whichever is shorter. Okay, second, in the statement of basis, the staff explains the ways in which cumulative impacts will translate into addressing cumulative impacts. Turning evaluation to action is critical, and we make 2 suggestions. First, the CAP rule specifically requires the commission to ensure that approved projects protect and minimize cumulative impacts. And we ask that similar provisions be added to Rule 307, or that the statement of basis specify that one of the ways it will address cumulative impacts is through Rule 307. We also ask that because the commission must address climate impacts, that at a minimum, the statement of basis be amended to specify that the commission intends to use cumulative impact evaluation to regulate oil and gas development proposals, including new permitting decisions, in keeping with Colorado's climate action plan. Third, we support the recommendations of the wildlife hunting and angling groups. Now, turning to alternative location analysis, the criteria for triggering an ALA is of critical importance and provide the commission with a powerful tool it needs to avoid impacts, including cumulative impacts. And we recommend that this tool be expanded to protect all Colorado's waters of the state. First, the waters of the state include ephemeral and intermittent streams. And second, an operator must already map all surface waters within 2,640 feet of working pad surfaces, and this includes ephemeral and intermittent streams. And third, the state of Colorado has gone to court to protect ephemeral and intermittent streams precisely because they're so valuable to Colorado and its environment. Therefore, we suggest that ALA be triggered when proposed operations are within or around riparian and wetland corridors, ephemeral and intermittent streams. Thank you.
Thank you, Ms. Walker, for that closing presentation. Do commissioners have questions? All right. Seeing none, we thank you for your participation and your closing. At this point, we are at 1:06, and I think we'll take our midday lunch break and reconvene at 2 p.m. And at that point in time, we still have about a dozen or so final closing statements this afternoon. So we'll see everyone at 2.